Minister of Foreign Affairs and International Cooperation.
Mr. Speaker, honorable members, I have the honor to lay on the table of this honorable House the following papers. Agreement between the government of the Republic of Sierra Leone and the government of the Republic of Rwanda concerning exemption on visa requirements for holders of diplomatic and service passports, dated 5th July 2019. General cooperation agreement between the government of the Republic of Rwanda and the government of the Republic of Sierra Leone, dated 5th July 2019. General cooperation agreement between the government of the Republic of Uganda and the government of the Republic of Sierra Leone for the establishment of a permanent commission for cooperation, dated 1st July 2019. Memorandum of Understanding between the Ministry of Foreign Affairs and International Cooperation of the Republic of Sierra Leone and the Ministry of Foreign Affairs and International Cooperation of the Republic of Rwanda on political consultations, dated 5th July 2019. And finally, Mr. Speaker, Memorandum of Understanding between the Government of the Republic of Sierra Leone and the Government of the Republic of Uganda on political consultations, dated 1st July 2019.
Government motion. The Minister of Foreign Affairs and International Cooperation.
Mr. Speaker, honorable members, be it resolved that this honorable House hereby ratifies the following agreements, which were laid on the table of the House on Thursday, 16th July 2020. 1. Agreement on cultural and artistic cooperation between the Government of the Republic of Sierra Leone and the Government of the State of Kuwait, dated 17th November 2019. 2. Agreement on cooperation in the field of technical education and professional training between the Government of the Republic of Sierra Leone and the Government of the State of Kuwait, dated 17th November 2019. 3. Agreement on establishing Joint Commission for Cooperation between the Government of the Republic of Sierra Leone and the Government of the State of Kuwait. Mr. Speaker, honorable members, in the reasonable estimation of both countries, the agreements aforementioned will further deepen and strengthen our bilateral relations and cooperation. The promotion of culture and arts will be a defining step in the new trajectory of relations, recognizing fully the artistic and cultural potentials we are endowed with, and how through relevant exchanges and support, we can midwife those values to have a profound impact on our development landscape. Mr. Speaker, honorable members, cooperation in the field of technical education and professional training will help crystallize our human capital development into them with the social development goals. And I dare submit further that the agreement to establish a joint commission for cooperation between our two countries will provide an overarching framework to support our mutual expectations. I therefore most respectfully pray, Mr. Speaker, honorable members, that this House proceeds to endorse and ratify the aforesaid agreements as Sierra Leone stands to benefit immensely from their implementation. Thank you, Mr. Speaker, honorable members, for your kind indulgence.
Honorable members, the question is that this House hereby ratifies the following agreements, which were laid on the table of the House on Thursday, 16th July 2020. The agreements that have just been outlined and mentioned by the Honorable Deputy Minister of Foreign Affairs and International Cooperation. I don't really think this is a controversial issue. So we can just ask the two leaders if they have any statements to make, and we proceed with the ratification.
Thank you, Mr. Speaker. Like you said, these agreements are non-controversial agreements. And as a country, there had already been relations between this country and the state of Kuwait. What the minister has just done is for us to put like an official seal to the relationship that we already had with the state of Kuwait. And bringing it to this House is only to give it the added significance that is required, so that as a country, we know that we have formalized, we have strengthened the relations between our country and the state of Kuwait. Like the minister rightly said, we must start to look at other areas now in terms of promoting our cultural values, and let us also try to encourage people from those countries to come with the aim of boosting our tourist industry, because those are areas that we've not been looking to. We've always been looking towards the West for tourists. But where there is an improvement in our cultural relationships, in terms of transmitting our values, definitely it will benefit our touristic industry and also our social and political values. And also we want to see how much we can benefit from states that are wealthier than us. So I think, like I said earlier, or like the Speaker said, they are not controversial. We'll only ask the rest of the House for us to speedily ratify this agreement. Let us strengthen the relationship between our country and the state of Kuwait. Thank you very much.
I thank the honorable member for his contribution and his statement on behalf of his leader. I will now invite the leader of government business.
Thank you very much, Honorable Speaker. Thank you very much, Honorable Chief, Honorable Opposition Whip. Are you sure that?
He was in the chamber, but not on his seat. You may proceed.
So are you satisfied with what your colleague said? It was very good. That was a very good statement. Yeah, this whole idea about the agreement is to strengthen our relationship with Kuwait, which has to do a lot of issues. One, it has to do with promotion of education in terms of music industry, in terms of technology, in terms of professional skills, for culture, in terms of training of our personnel. That has to do with the technical education and professional training. You know, we have now the polytechnic institutions. So it's good for us to strengthen our relationship with Kuwait and also to do knowledge sharing. It also has to do with our children, for the other agreement, to improve the skills of our children in terms of culture and the artistic education. So for me, as you said, it's non-controversial, and the responsibility lies on the individual states to ensure that they strengthen their relationship and work within the framework of the agreement. And let us follow the text in this agreement so that we can benefit from it as citizens of this country to improve in the technical, professional, and also the cultural practices that both countries will have to benefit from. So we said education is also paramount in this agreement. If you look at Article 3 of the Agreement on Cooperation in the field of technical education and professional training between the two countries, it's very key in Article 2, Article 3. All what we need to do is to ensure that we have the requisite requirements for us to put this agreement into full gear. Mr. Minister, we expect that this is not business as usual. You have to do some work. For example, for the other agreement, there are certain frameworks that you need to put in place before that agreement comes into effect. So you have to do it, not about rhetorics, say, we put it here, we ratify it, and you just put it in the shelf. You have to do so many things to ensure, because I know this agreement, all of them, you have to do certain things, you have to take certain steps to ensure that this agreement comes into practice, because we have to benefit, especially for our children. It's clearly enshrined in one of the agreements that has to do with the skill training of our children. Thank you, Mr. Speaker. Thank you, Honorable Alsan Sisi, for that brilliant remarks about the agreement. Thank you.
Mr. Minister, do you have anything to add?
Mr. Speaker, just to indicate that I cannot agree more with the sentiments expressed by honorable members, and I am immensely indebted, and to communicate that we pledge our full faith and commitment, specifically the Ministry of Foreign Affairs and International Cooperation, and by extension the government and people of Sierra Leone, to discharging the obligations on the part of Sierra Leone with respect to the said agreement. And I'm truly indebted, and I communicate that assurance to this honorable House. Mr. Speaker, honorable members, be it resolved that this honorable House hereby ratifies the following agreements which were laid on the table of the House on Thursday, 16th July 2020. Agreement on cultural and artistic cooperation between the government of the Republic of Sierra Leone and the government of the State of Kuwait, dated 17th November 2019. Agreement on cooperation in the field of technical education and professional training between the government of the Republic of Sierra Leone and the government of the State of Kuwait, dated 17th November 2019. And agreement on establishing Joint Commission for Cooperation between the government of the Republic of Sierra Leone and the government of the State of Kuwait. Thank you, Mr. Speaker and honorable members, for your kind indulgence.
I thank the Honorable Minister, and I extend the same to the Chief Whip of the opposition, who spoke on behalf of the Leader of the opposition and the Leader of government business. Honorable members, the question is that the House ratifies the agreements that have been read out by the Deputy Minister of Foreign Affairs and International Cooperation, which were laid on the table of the House on Thursday, the 16th of July, 2020. All those in favor say aye. All against say nay. The ayes have it.
Government motion by the Deputy Minister of Foreign Affairs and International Cooperation has been ratified.
Bills.
Mr. Speaker, 1 minute. Just to bring the House to speed, for the first document laid, It was laid on the 17th of March, Tuesday, 17th of March, 2020. So check your records for the first document laid for Minister of Finance, Foreign Affairs, so that when we have the motion for the debate, we don't make reference. So we have the copies of that particular document. Thank you.
Bills. 1. The Consumer Protection Act 2020. Introduction and first reading. The Minister of Trade and Industry.
Mr. Minister, you have the floor.
Mr. Speaker, honorable members, civil society groups, media representatives, distinguished guests, ladies and gentlemen, I lay before this House the Consumer Protection Bill that we Mr. Speaker, honorable members, I move that the bill entitled the Consumer Protection Act 2020 be read the first time.
Thank you. Honorable members, the question is that the bill entitled the Consumer Protection Act 2020 be read the first time. All those in favor say aye. Those against say nay. The ayes have it.
The bill entitled the Consumer Protection Act 2020 has been read the first time.
Mr. Minister, you may return to your seat. Very well.
Speaker, with your permission, I rise on SO 37. Thank you very much, Mr. Speaker. Mr. Speaker, as I said, I rise on SO 37. Considering the volume of the bill we are expected to discuss, and the exchanges that took place during the pre-legislative hearing, I want to crave the indulgence of this House, through you, Mr. Speaker, that we postpone the debate, that is the second reading, to any date convenient for this House, Mr. Speaker, so that members will have ample time to read this document and digest it properly, for them to be in an informed position while debating it. That is my motion, Mr. Speaker.
Leader of Government Business.
Mr. Speaker, I expect you to put the motion, so I second the motion. I'm in full support of that motion, so I second the motion.
Honorable members, the motion is before the House. All in favor of the motion say aye. All against say nay. The ayes have it.
Motion moved by the leader of the opposition has been approved.
Mr. Minister, thank you. You may go back to your seat.
The Independent Media Commission Act 2020, committee stage and third reading. The Minister of Information and Communications.
Committee stage, Sergeant at Arms.
The House resolves into committee of the whole House.
Leader of Opposition, please come forward. Honorable members, the Minister of Information is now with us. I understand, in fact, today is a Cabinet Day, but because of the importance of the matter before the House, he has graciously decided to set aside his Cabinet duties to come to the House and continue the pleasant duty of piloting this bill through to finality. Mr. Minister, you are welcome. And I also want to take this opportunity to welcome the great media moguls who are here today. I see Asma James of 98.1, who is with us. And many others. Prepare the list for me. The clerks will now please brief Mr. Minister so he can take his seat. We are at committee stage now.
I call on the Chairman, Legislative Committee, Honorable Hedolo Moyo Givao, to present the report.
Mr. Speaker, honorable members.
This is committee stage.
Before
This is committee stage.
Mr. Chairman, I apologize. It was a luscious lingua. Mr. Chairman, honorable members, before commencing the presentation proper, I must say members of the Fourth Estate must have appreciated the enormous work that we members of Parliament put into our job. During committee stage, we were on this bill till 8:15 to 8:30 on the day that the committee sat. I'm happy to state it because they are the ones that actually relate everything that we do to the public. It was so much of a daunting task, but we thank God we were able to do our job, and today we have a report that we can present to the committee of the whole House. Mr. Chairman, honorable members, hereby present the first report of the Legislative Committee, third session of the 5th Parliament of the Second Republic of Sierra Leone on the bill entitled the Independent Media Commission Act 2020, presented to Parliament on Thursday, 23rd July 2020. Introduction. Mr. Chairman, honorable members, I rise to present the first report of the Legislative Committee, third session of the 5th Parliament of the Second Republic of Sierra Leone on the bill entitled the Independent Media Commission Act 2020, being an act to provide for the continuation of the Independent Media Commission, to provide for the registration and regulation of mass media institutions in Sierra Leone, license of registration and regulations of mass media institutions in Sierra Leone, license of institutions engaged in radio, television, or direct-to-home digital satellite services, broadcasting and registrations of persons and institutions engaged in the publication of newspapers and magazines in Sierra Leone, and to provide for other related matters. Mr. Chairman,
honorable member.
Yes, Mr. Chairman.
Let me just guide you as to the procedure that I would want us to adopt. In the first instance, I would ask that you read your report right through from start to finish.
Much obliged.
And then we'll dissect the principal bill into parts.
Grateful.
And then I will invite you again to introduce your report part by part.
Much obliged.
That way it will be much easier.
Grateful, Mr. Speaker. Mr. Chairman, honorable members, the bill having gone through the second reading was committed to the Legislative Committee for scrutiny pursuant to Standing Orders 51, Sub-Rule 1 and 3. Subsequently, the committee met on Monday, 20th July 2020 in Committee Room Number 1, Parliament Building, with the following objectives. 1, to scrutinize the detailed provisions of the legislative proposal after the second reading in the House, to ascertain the constitutional and legal implications contained therein, and to report to Parliament in accordance with the provisions of the standing orders of this Honorable House. Mr. Chairman, honorable members, in attendance were the Minister and Deputy Minister of Information and Communication, Commissioners of the Media, Commissioners of the Independent Media Commission, officials of the Sierra Leone Association of Journalists, and Parliamentary Council who made meaningful contributions to the hearing. Recommendation. Mr. Chairman, honorable members, the Legislative Committee, having scrutinized the bill line by line and clause by clause, recommends the following amendments to the House for approval. 1, the short title of the bill be approved. 2, the long title of the bill be amended by deleting the words persons after the words license of. 3, Mr. Chairman, honorable members, the committee agreed that wherever the words newsletter appears in the bill, it be deleted. 4, Part 1, preliminary. 1, from the definition of the words chairman to the definition of the words Sierra Leone Association of Journalists be approved. 2, the definition of Sierra Leone Institution of Engineers be amended to read Sierra Leone Institution of Engineers. 3. The definition of Tertiary Education Commission be approved. 4. Mr. Chairman, honorable members, the committee made consideration on the following definition to be included in the interpretation section. A. Media practitioner means a person engaged in the writing, editing, or transmitting of news and information from a registered media outlet under this act, including freelancers. Mr. Chairman, honorable members, the committee attempted to define the words public interest, but due to endless contentions, the committee agreed that this definition be left for plenary to define if necessary. 5. Part 2, continuation of commission. 1. That clause 2 be approved. 2. Clause 3 be amended as follows. A. Paragraph C be amended by inserting the words, one of whom shall be a woman, immediately after the words print journalism. B. Paragraph E be amended by deleting the word institute and replacing it with the word institution. C. Paragraph F be amended to read two nominees from Interreligious Council of Sierra Leone. Mr. Chairman, honorable members, the committee proposed the insertion of a new paragraph H to read, a representative of the Sierra Leone Association of Journalists nominated by the Sierra Leone Association of Journalists. D. Clause 3, subclause 2 be amended to read, the chairman shall be a person with proven relevant practical experience of at least 10 years as a media practitioner appointed by the president, acting in consultation with the Sierra Leone Association of Journalists and subject to the approval of Parliament. 3. Clause 4 be amended in subclause 2, paragraph D, by inserting the word sexual offenses. 4. That clauses 5, 6, 7, 8, 9, and 10 be approved. 6. Part 3. Objects, functions, and powers of commission. That clauses 11, 12, and 13 be approved. 2. Clause 14, subclause 2 be amended by inserting intends to immediately after the commission. 3. Clause 15. Mr. Chairman, honorable members, the committee proposed the insertion of two new subclauses, 4 and 5, and to read A. 4. The commission shall proceed to cancel or suspend the license where the holder of the license fails to comply with paragraph B and C. B. 5. The commission shall restore the license when the holder remedies the situation and gave cause for the cancellation or suspension. 4. Clause 16 be amended by inserting signed by the High Court immediately after the words warrant. 7. Part 4, administrative provisions. That clause 17 and 18 be approved. 2. Clause 19 be amended as follows. A. Subclause 1, paragraph A be amended by inserting at the end of the sentence the following words, for newspaper and magazine. B. Subclause 3 by deleting the words with and replacing it with the word by. C. Subclause 5 by subclause 5 be amended by inserting the following words, and an affidavit of service duly served by the commission immediately after the word's appearance. D. Clause 7, paragraph B be amended by deleting the word cost and replacing it with the word fine. 8. Part 5, financial provision be approved. 9. Part 6, license and registration. A. Radio, television, and digital satellite service. 1. Clause 24 be amended as follows. A. Subclause 2 by inserting a new paragraph C to read, C. Has a registered business as a sole proprietor. B. Subclause 3, paragraph B. 3. AA to delete the year 2001 and replace it with 2002. C. Subclause 3, paragraph B, 3, CC, by inserting the following words at the end of the sentence and its amendment. D. Subclause 5 be amended to read, a person who contravenes subsection 1 commits an offense and is liable on conviction for a fine not less than 15 million leones and not more than 30 million leones, 2. That clause 25 and 26 be approved. 3. Clause 27, subclause 3 be amended to read, the procedure for the renewal of a license shall be with the Commission regulatory requirements. 4. That clause 28 be approved. B. Newspaper and magazines. 5. Clause 29 be amended as follows. A. Subclause 1 be amended to read, a person or media institution who publishes a newspaper or magazine shall apply to the Commission for registration of the newspaper or magazine. B. Subclause 2, by inserting a new paragraph C to read, has a registered business as a sole proprietor. C. Subclause 3 be amended in paragraph B, 3AA by deleting the year 2001 and replacing it with 2002. D. Subclause 4, paragraph B be amended by deleting 60 days and replacing it with 1 month. E. Clause 5 be amended to read, a person who contravenes subsection 1 commits an offense and is liable on conviction for a fine not less than 15 million leones and not more than 30 million leones. That clause 30 and 31 be approved. Clause 32 be amended by correcting the spelling of the word certify to satisfy. Clause 33, subclause 3 be amended in paragraph C by deleting the words where it and replacing with the word where it. Clause 34, subclause 3 be amended to read, the procedure for the renewal of a license shall be with the Commission's regulatory requirements. That clause 35 be approved. Clause 36 be amended by inserting the words or sole proprietorship immediately after the words partnership. Clause 37 be amended as follows. A. Subclause 1, by inserting the words or sole proprietor immediately after the word partnership. B. Subclause 2 be amended to read, a person who contravenes subsection 1 commits an offense and is liable to conviction for a fine not less than 15 million leones and not more than 30 million leones. Clause 38 be amended as follows. A. Subclause 1, by inserting the following words at the end of the sentence, in the case of a partnership or sole proprietorship, the managing partner or sole proprietor. B. Subclause 2 be amended to read, the signed copies of every newspaper or magazine delivered to the Commission under subsection 1 shall be submitted on the day of publication and shall be filed and kept by the Commission. C. Subclause 3 be amended to read, an editor and publisher of a newspaper or magazine who contravenes subsection 1 commits an offense and is liable to a fine not less than 3 million leones and not more than 5 million leones. Obligations to employ registered editors and station managers. Clause 39 be amended on the proviso to read as follows, unless that person is a media practitioner. Clause 40 be amended as follows. Subclause 1, by spacing the words otherwise engaged to read otherwise engaged. B. Subclause 1, paragraph B be amended to read, has obtained a diploma in journalism, mass communication or media studies, or a university degree from a recognized institution. Miscellaneous provision. Clause 41, subclause 2, paragraph B be amended to read, newspaper and magazine registered with the Commission. That clause 42 be approved. Clause 43 be amended to read, the minister may by statutory instrument after consultation with the Commission and the Sierra Leone Association of Journalists make regulations for giving effect to this act. That clause 44 be approved. Conclusions. Mr. Chairman, honorable members, the Legislative Committee, having scrutinized the bill entitled the Independent Media Commission Act 2020, recommend these proposals to the House for approval. The report reflects the consensus of honorable members of the committee. I therefore move that the House pass the bill entitled the Independent Media Commission Act 2020 through committee stage, third reading, and into law. I thank you for your attention. Signed, Honorable Hindolu Mwewo Gevao, Chairman, Legislative Committee.
Parts 1 and 2, parts 1, 2, and 3, clauses 1 to 16, stand part of the bill.
The Right Honorable Speaker. Mr. Chairman, honorable members, I move that parts 1, 2, and 3, clauses 1 to 16, stand part of the bill.
Honorable members, the question is that parts 1, 2, and 3, clauses 1 through to 16, stand part of the bill. We'll now take it page by page. Page 1. There's a long title. Yes, Mr. Speaker. Yes, the word persons appeared twice in the long title, and we agree that the committee stage to expunge persons in the long title, not only the one that appeared after license of, the one that also appeared after registration of. So both words should be expunged from the long title.
Mr. Speaker, with your permission, sir, by way of a guide, when members are making their contributions in amending, either by adding or deleting, they should also do it in tandem with the report, so it will make it easier. Otherwise, we'll have a report that we'll have adopted that makes no sense. And I'm sure the chairman is paying keen attention, so that when members raise issues, they will be synchronized with the report itself. Very, very important.
Yes, in line with what my leader just said, I'm referring to the recommendations to the long title of the bill be amended by deleting the word persons after the word license of. I was just trying to say it is not only after the word license, but it should be again after the word registration of, because persons appear twice in the long title. So for the edification of the House, will you now read the long title. Yes. Taking into account the amendment you want.
Yes, being an act to provide for the continuation of the Independent Media Commission, to provide for the registration and regulation of mass media institutions in Sierra Leone, license of institutions engaged in radio, television, or direct home digital satellite service broadcasting, and registration of institutions engaged in the publication of newspaper and magazine. Yes, in Sierra Leone, and to provide for other related matters. We also consensusly decided, as stated in recommendation 3, to delete the word newsletter.
Mr. Chairman, may I? Mr. Chairman, I take what my colleague is saying, but my memory vividly serves me that we decided to omit one, the persons appearing only once to avoid tautology, it appearing twice. So we only agreed to omit the word of persons, which is captured in the report, because we would want a long title to also include registration of persons. So if you delete the word persons, then you are omitting a facet of the people that the bill envisaged to capture, like freelancers. So we cannot totally remove the word persons from the long title, because freelancers are envisaged in the body of the bill.
Mr. Speaker, I support the submission of the chairman, considering the fact that also in the body of the bill, we have added the business of sole proprietorship, and that is an individual. So you cannot, they don't have corporate status, so you cannot take out persons. I agree with you.
Mr. Chairman, Mr. Chair, I think there's a different opinion.
Mr. Speaker.
Yeah, leader.
I think they have talked about like what the honorable leader of the opposition said. For me, I think we should just take the recommendations from the one coming from the legislative committee, because it gives us the insight of the bill. If you read it and what the changes that they have made already in the committee, it gives us the insight of the bill. Because if you move the persons, it has something to do with the text in the bill. So we should leave it like that. We should leave it like that, Mr. Speaker. So just read it again, and you look at talking about sole proprietorship. It's a corporate body we are talking about. So the one should remain. And taking up the first one is very necessary.
No, it's not.
The first of persons.
Yes. Yes.
But we'll keep the second.
The second, yes.
No, sir. Mr. Speaker.
Mr. Chairman.
Mr. Chairman.
On the same issue?
Yeah, on this same issue.
Okay.
It's completely different from what leader is saying. And I agree with what leader of opposition is saying. That the first one in the first place relates to licensing. And the second one relates to registration. And the bill makes provision, even an extra provision of which I support, to sole proprietorship. And as a sole proprietor, you cannot be an institution following the word licensing. You cannot be referred to as an institution following the word licensing. Taking into consideration the provision for sole proprietorship, you as an individual cannot be referred to as an institution if you are a sole proprietor. And I think it causes no harm. It even supports the extra provisions recommended by the committee. It's in further support of the extra recommendations to put their sole proprietorship. And if you check this first person, if that person is removed, the next word to be followed is institution. And a sole proprietor cannot be referred to as an institution.
So what are you proposing?
So we are proposing, as leader of opposition said, both should remain. It is even in further support of the object of this bill. It should remain because the bill makes clear provision for sole proprietorship, which cannot be referred to as institution in terms of licensing. Meaning, if you are not an institution, you cannot be licensed as a sole proprietor. And the licensing will be limited to only institutions. While at the same time, there is strong reason for us to include sole proprietorship. So to me, retaining both causes no harm, absolutely, to the object of the bill. While on the contrary, it further supports the inclusion of practitioners being sole proprietors. It further supports that one. But if you remove this one, it undermines.
You've made your point. Let's listen. Where is
Mr. Chairman.
Where is the chairman? Will you please go to your allotted seat?
Mr. Speaker, we need him at our back. Mr. Speaker, you remember you suspended the standing orders 3-2 for the COVID. So we are just moving here. We want to have consensus on this. We don't want to cross at hypocrisy because
no. Give me another excuse for wanting him there.
For COVID, the other one is.
Give me another excuse. The excuse you want
more information
for consultation.
Mr. Leader. No. We don't want to reach that stage.
Honorable members, Honorable Kagbo, I hope you're paying attention.
Yes, sir, Mr. President.
Because you raised this problem.
Mr. Chair, can I have an opinion on this, please?
My attention has been drawn to clause 24, for example, and I understand there are similar clauses in the bill. If we were to go the way you have asked us to go, how would that be consistent with the provision of clause 24? since the bill also has come to us now, capturing a provision dealing with sole proprietorship.
Mr. Speaker, I go by what the leader said.
So you withdraw?
Yes, sir.
Thank you.
Thank you.
And therefore, we keep the long title of the bill as it is. Is that agreed? Thank you.
Mr. Chairman, can I be heard on this for clarification, sir?
Which one?
This same title, sir, for clarification. No, but can I be heard, Mr. Speaker, Mr. Chairman?
Okay.
Since the media practitioners are here and the minister himself is here, I just want to clarify. The persons we are referring to, is IMC holding the person responsible or the entity in case of any breach?
If you decide to convert yourself to a sole proprietor, they will hold you responsible. If you are a corporate body, they will deal with the corporate body.
If I'm a sole proprietor, I'm registering C&J Enterprises.
They will hold you, not C&J. They will hold you.
I then rest my case.
It's a sole proprietorship, so you are not covered.
Mr. Speaker, Honorable Leader, I was expecting you to just go back to the reference you made in Section 24. So, yeah, just because it's addressing, yeah.
Planning to register a business as a sole proprietor, you should also be prepared to carry the burden. You cannot benefit from what you are not entitled to. Mr. Deputy Speaker, please tell him.
I think the consensus around the House is that we keep the long title as is. Page 2. Page 2, part 1. Does this appear here? Where?
Mr. Chairman, on page 2, from the report, you notice that we did say attempts were made to see whether it was prudent for us to define the word public interest.
No, before we reach that point, where does the word newsletter appear?
The long title. In the long title and several other parts of the bill.
And the consensus is that you delete that word wherever it appears.
Yes, Mr. Chairman.
So I don't need to put that to a vote. Fine. Thank you. Go on then.
Yes, on page 2, it has to do heavily with the interpretation section. Even though the word public interest doesn't appear in the interpretation section, but it was suggested at committee stage that we endeavor to have a definition of public interest.
Mm-hmm.
But we referred it to the plenary for us to see whether we should, if necessary, or we should not. Then there was another opinion that in the body of the bill, the word public interest be deleted because of the effect that members said it will have on the media institutions. So we'll have to look, if we say we define public interest in the interpretation section, it will be perceived that we'll be keeping the word public interest in the entire body of the bill. But if we say we don't define it in the interpretation section, maybe when we reach to areas where there is public interest, we will now have to look at it from its text, whether it should be retained in the body.
What about, okay, and what do you want, Mr. Chairman? I give you the prerogative of telling the House now what you would like to advise.
Mr. Chairman,
do we define it or we leave it?
In all fairness, it is my wish that we delete the word public interest in the entire body of the bill. And if so, we will not be defining it in the interpretation section of the bill. Because public interest, no matter how you define it, when we did the research, we've not been able to define it in any of the bills that we have passed in this House. So, no matter how we define it, it might be a little subjective or different from another interpretation.
Not a little, not a little.
Or substantial.
Let us accept the fact that in this particular instance and in many other instances, it will be subjective.
It's heavily subjective. I take the cue, Mr. Speaker. So because of its subjective nature, it is my submission that we get rid of it in all areas of the bill where it appears. And in that case, there will be no need for us to define it in the interpretation section.
Any other view on this?
Mr. Chairman, I think we don't need to have other view on this. It's very clear. Even in the primary law, we have the Constitution. Public interest, in fact, mentioned in Section 50 of the Constitution, talking about freedom, did not define public interest. Because it's imprecise and very subjective a clause. For me, law just delete it completely from the bill. So it will not cause implications. Because if you say public interest, what parameters are you going to use to define public interest? So it will all be subjective that I will take parameters that suit my comfort, so that I can make judgments against that individual. So let us delete it entirely from the bill. That is my submission.
You draw attention to the Constitution.
Oh yes, Section 15. There is something about freedom. Let me just read if you don't mind. Let's also talk about 15B, D. The paragraph below. The subsequent provision of this chapter shall have effect for the purpose of affording protection to the aforesaid rights and freedoms, subject to such limitations of that protection as are contained in those provisions, being limitations designed to ensure that the employment of said rights and freedoms by any individual does not prejudice the rights and freedom of others or the public interest. You have explained that one in chapter 3 of the Constitution, where in the Constitution they did not define public interest. And this particular bit has to do with freedom of people, freedom of expression. That's what I'm saying.
Mr. Speaker, Mr. Chairman. Mr. Chairman, when we were in the committee, there was this urge to define public interest. More so when we are looking at Part 5 critically, and now we'll be subjected to go to court on civil. Together with the minister, we said, looking at public interest as a parliament and at this plenary, and giving it a definition will be good, because it will limit the interpretations in the courts, because what deems to be public interest in one situation might not be public interest in another situation. And if we are retaining it in the bill, we are asking that we define what really is public interest. Because we don't want to see a situation where an article will be carried against the IG and they tell us it's a public interest. Sorry, sir.
Mr. Speaker, we don't want to be here for the whole day. Though where the chairman has made his proposition and we have agreed, there is consensus. We should not be debating issues that we have consensus in. We don't need to be convinced anymore. We are convinced. We will only discuss areas. So, Mr. Speaker, Mr. Chairman, I'm kindly pleading with you to ensure that wherever there is consensus, no more justification will proceed.
Mr. Speaker, may I be heard on this?
Mr. Speaker,
Yes.
Mr. Speaker,
Mr.
let me
Speaker.
say this. Let me come
Mr.
in.
Chairman.
Point of order, 34.
Yeah.
If you are in the committee, if we have report from the committee, and the chairman has said, let us delete this one. You are not able to define it. You have no business to convince us here. Our business here said by the honorable leader of the opposition is for us to accept this consensus. We delete it. So what do you want to be controversy on this clause? And you are in the committee, you are not able to define. You are giving the whole attitude to define it for us. So for us, we take the cue from the chairman of the committee, Mr. Chairman. With all due respect, let us go ahead, or I will be here for the rest of the day.
Leader. I have a pair of spectacles for sale. Well, I think, honorable members, we've had the recommendation of the chairman of the legislative committee. I've also invited the two leaders to come forward for consultation. There is no doubt in my mind that any attempt to define the term public interest is going to keep us here for the rest of the day. It's a very difficult term to define with any precision. Yet, let us admit that even in our ground norm, the national constitution, there are various provisions that contain that phrase, public interest. It's a matter that is best left either to the state to determine or the courts to determine. When I saw it myself this morning, I tried to come to a definition, and I was not particularly convinced that it was a good one. And what I came up with, that which is best for society as a whole. But that is my own subjective. I decided to discard it because it is imprecise. So we go along with what the chairman has suggested. So the consensus is we delete the word wherever it appears. We just delete. It's too great a power to entrust to the body.
So as we progress, if you take keen interest, you look 14, 15, and 16, you will see them appearing there, just for you to keep eyes on it, and you see how they were used. So you delete, and it will make sense.
So give us an example, for example. You said
so
14.
Under 14B, we turn to 14B. I'll read the entire. The commission may suspend a license or cancel a license where it is satisfied that the holder of the license has violated a term or condition of the license, or 2, within 6 months period, contravene the media code of practice more than once. 3, it's in the public interest to do so.
So we delete the B.
We delete the
B. That's what you say.
Yes, we delete B.
Good.
That's 14. Then the same applies to 15. Yes.
So the consensus, honorable members, is that the phrase public interest be deleted from the bill wherever it appears. That is what you are proposing, Mr. Chairman.
Yes, Mr. Speaker.
I don't want to put it to a vote.
Mr. Speaker.
I presume there is a consensus on
Mr. Speaker, as we go along, we try to contextualize where public interest is, and we try to look at the particular interest in that particular phrase. For example, no. We cannot use the word public interest, is what we are talking about. But the text of it following for us to have public interest, we look at it. It's the word public interest. Let us move along. Let us just accept it. But when we reach, we look at the context and we look how it applies to what we are doing, and we paraphrase the word public interest, and we have a particular definition of what we want to put there. We always consider about public interest. I know what I'm saying. I've read this bill. So anywhere we make public interest, we look at it, but we don't use the word public interest. Oh, when we get there, we'll cross that bridge. When we reach there, we'll cross that bridge. We are making laws. Where we have public interest, honorable leader. Okay.
Yes, Mr. We are going around the same cycle. We have agreed that the word public interest has no place in this bill. Stage 1. The chairman has also said that whilst we make progress, because we are going page by page, if there is something we need to address on a particular page, we'll address it, be it by way of phraseology or otherwise. So let us make progress. We are just going around the same cycle.
Mr. Chairman, please, I want to add my...
On the same one?
Yes, sir.
You will be the last speaker.
Okay. It is...
I'll make it short and sweet.
It is very important that when we make law that we take into consideration some other prevailing circumstances in our society. We have had issues of public interest we have considered as public interest. Let's say, for instance, the audios that sweep around our society and some other things that can bring chaos in our society. Is that not something we consider? Like different people staying abroad, and we have a fleet of journalists all over the world today. They are there, they will send issues to us. Can that not be considered as a public interest? Cannot bring it undermining our democratic fabric of our society?
Okay, you made your point?
Yes, sir. Thank you.
Let me just draw your attention. This document that I hold here is the National Constitution. I will refer you to sections 15. Another one is section 104. And there are many others. And the phrase public interest is used in the Constitution. But the framers of this Constitution were careful not to offer any definition, for good measure. So let's be guided by them. Maybe there is wisdom in just not trying to define it. Are you satisfied? There is no definition in the Constitution of public interest. So the consensus is we avoid any definition of the term public interest. Shall we then proceed?
Mr. Speaker. Mr. Chairman.
Where were we? Page 2 and 3. Now page 4. Part 2. Yes.
Sorry, part 1. I was waiting for the chairman to exhaust. Mr. Chairman, please. I also suggested, before I left the meeting for the ECOWAS meeting, for the words Auditor General to be defined. Because the Auditor General appears in the bill. And like in all other laws, in the Constitution, it will say the President means the President of the Republic of Sierra Leone. The police means the Sierra Leone police. So like we have done for others here, Mr. Speaker, they will tell you that minister means, we know who's the minister, but they have defined the minister for specificity. So it is good for the Auditor General to be defined. Mr. Chairman, are we together?
Yes,
sir.
That suggestion did came up. That
Yes,
we
I was not there,
define-
that's why.
Yes, that we
Because it's
define
very
Auditor
important
General.
that we define the Auditor General for the
So
Republic of Sierra
we
Leone.
did say, the Auditor General means Auditor General of Sierra Leone.
Yes, very important.
Yes, Auditor General means the Auditor General of Sierra Leone.
Honorable members, I presume there is agreement on that? Thank you. Auditor General shall mean the Auditor General of Sierra Leone. We'll go to the auditor. Part 2, page 4.
Yes, Mr. Speaker.
Recommendation is that clause 2 we have no problems with. Clause 3 is where there is a recommendation.
Mr. Speaker.
Who was trying to? Yes?
Yes. I have a problem with clause 25.
25?
Yes, but he said should be approved.
25, we are not there yet.
Okay.
It's not from BT, but is from the city of Putloko, not from the village of Binti.
Mr. Speaker,
Yes.
I have a problem with part 2. we have people who are media sensitive in the civil society. The last time the minister was saying, of course, yes, in the broader term, Interreligious Council, they are part of the civil society. We are talking about specifics. So if you are saying we want to have people who are monitoring the media regulation, because this whole business about regulations. If you talk about Interreligious Council, really what comes to your mind is about prayers, business, holiness.
What clause specifically?
Is this clause 3 of part 2. Is what I'm talking about. I'm just looking at the composition of the different. They told us they gave us clause 3. It said paragraph F be amended to read 2 nominees from Interreligious Council of Sierra Leone. For me, I want us the status quo to remain the same. For the Interreligious Council to have 1, and let us look at CSO that are practically related to media issues. We give them the opportunity to be one of the commissioners. I think that one is. But when you talk about Interreligious Council, what comes to your mind is holiness. Really holiness. So that gives us the integrity of the independent. I got Professor Saban Sandy. So I want also to split that one. To give those in the civil society that are media related. Mr. Chairman.
Mr. Leader, I think we had similar opinion, but the problem we were faced with, we had wanted to give CSOs 1 representation, but it appeared as if there is no umbrella body called CSO. So when we say CSO 1 representation, then somebody will say, who will nominate them? They have this, they have this, they have that. So we had so much argument over CSO. That one came up, we spent about 30 minutes on it. If you say a representation from CSO, who will nominate the nominee?
Mr. Chairman, I differ from the chairman's explanation completely. If you say, if the minister is going to nominate somebody to represent, he said, if you go to page 5, G, 1 representative of the ministry nominated by 1 representative of the ministry nominated by the minister. So this one also, let's have faith in the ministry. We also give them the latitude to look around. No, I'm coming. Don't make law because you are now in the opposition, because you are in charge. It will come to you one day. So I'm coming. Let me tell you. But what we are doing, what you are saying, is media related. We have CSO who are media related. So if you are giving them the responsibility, you can say, look, let us have it in the interest of representation. Well, Slango, that's fine. Thank you very much. Slango, they are in charge of the minister can. We need a minister intervention on that. I don't want us to give this one all to the Interreligious Council. Minister, we need your guidance in this. Can you come aboard?
Can I come in, sir, before the minister?
I'm still on my legs. I have not been given the floor. Wait, my brother.
Right, sorry.
Mr. Chairman, they are saying for us, giving enough.
Mr. Speaker, the time is past 12. I suspend as a 5 to. Thank you.
Next, Honorable Leader, try to stand on this proper standing order. Just cut off like that. So let him do the appropriate thing, Mr. Speaker. You need to stand on the appropriate standing order. I'm still on my legs. Let him give me the appropriate standing order. Are you now?
Exactly.
Any seconder?
I so second, Mr. Speaker.
All in favor say aye. All against say nay. The ayes have it. Be prepared though, because you will have to make another motion at 3. At the rate we are going.
Mr. Chairman, why I'm saying this, if you go back to the composition of part 2, Mr. Chairman, I want you to again to answer this for us. We know we have given a lot of chances to Sludge, Mr. Chief, to Sludge, to give Intelligence Council. Are you?
Step by step?
Yes, let's address.
Okay, I concede.
Thank you, sir. Mr.
Okay.
Speaker, Mr. Chairman.
In view of this, Mr. Chairman,
Mr. Chairman.
can I be heard, please?
Can I be heard? Can I be heard?
Today, Nabulio.
Yes.
Mr. Speaker, though we are dealing with the media-related issues, and my leader there is saying we should not include much of the faith-based people. But again, let's have this at the back of our mind that we now have radio stations which are faith-based. We have television stations.
Mr. Speaker, point of order. Point of order, Mr. Speaker.
Which order?
34.
Uh-huh.
Mr. Speaker, I said during the course of the debate on Thursday that those who have interest should disclose. This particular clause we are talking about, those who are preachers, the issue that has to do with the Interreligious Council.
Yes.
Those who are pastors and imams, lay preachers or otherwise, should give us space to debate this on a level playing field. I can see Sama Sandi, AKK, Abdul Kagbo, they know themselves. They know themselves.
AKK included?
Yes, and honorable.
No,
AKK is a lay preacher. They know themselves.
No.
Hey, Mr. Speaker, I'm not done yet. Mr. Speaker, he's a lay preacher. He conducts services in church officially. Advise Abubakar, the Marxists, he should also not talk. So, Mr. Speaker, I'm kindly pleading with you that we should not be convinced.
Wait a minute. This is news to me. I know of Abdul Kagbo, but AKK.
Mr. Speaker, he's a lay preacher.
Mr. Speaker, Emerson and AKK are on the same platform. And Emerson has just been ordained. But you see, so they should not participate in this. If you want to say something, you say it, but don't convince us about the Interreligious Council.
Mr. Leader, that is actually not the position I'm coming from. I am saying, in as much as we are talking about IMC code of conduct, in this, we also look at faith-based television stations. Their content is different from what normally we get from other radio stations. If they are in conflict with the law, at least at that level, let's have people there who can understand their content better. Say, for example, you have an issue with the Ahmadiyya radio station that has to do with purely Islamic doctrine that they've given out. You need somebody in that board who understands what it means, what the content entails. No, that is why we are saying two, because you are having Islamic and also possibly the Christian faith. So we are saying let's have them both. The issue is when we say normally we talk about civil society organizations, they will just appoint anybody from anywhere. But let's limit this one to Interreligious Council.
Okay.
Mr. Speaker, for your knowledge, I am a trained and qualified theologian.
This is news to me. This is news to me.
Yes, Mr. Chairman. Mr. Chairman.
I recognize the first name, not the middle name. Otherwise, I'll ask you to sit down.
Well, unfortunately, Mr. Speaker, even that is not a middle name, sir. That's an AKA.
Mr. Speaker, has he caught your eyes
It's
now?
an AKA,
Can I sit down?
not a middle name. I am Honorable Hassan Abdul Sise.
AKA?
That is AKA, which is not official, sir. Mr. Speaker, unlike the case of Abdul Kagbo, who is soon to be referred to as a pastor. I am not.
Really?
And
I'm already
AKK,
on
who is
this,
a
sir.
trained theologian, will become ordained very soon. I will not be ordained. I'm a Muslim. So mine is an AKA. It does not qualify in this particular subject. let's make progress here. That is a discussion for another day. Mr. Speaker.
But I'm curious.
Well, you see, these are all efforts to derail us from this very important.
Where did the priest come from?
Mr. Chairman, I promise you that will be a discussion for another day.
Mr. Speaker, Mr. Chairman, can I help him to explain?
No.
How can you? Because I know.
How can you?
Because I know, Mr. Speaker, where he got the priest name from.
But he says let's leave it for another day.
Mr. Chairman, am I protected?
Yes, you are.
Thank you. So please have your. Mr. Chairman, what I think on a more serious note here, having a member of the Inter-Religious Council, like the leader was saying, just might bode well. We don't want, because wherever there is a Christian and a Muslim representative, there is a tendency for there always to be a clash of the two religions in terms of how they believe. So somebody, faith is faith, and the interest of what we are trying to protect here is the interest of radio stations, magazines, etc., etc. So I think if we have one person from the Inter-Religious Council, that would be enough rather than having two. I think that is what I want to believe, whether it's a Muslim or not, but there must be something related to them to represent them as the Muslims and Christians, rather than having two, because there are other people who might be more relevant to the commission than they might ought to be.
Okay, let me ask the chairman.
Mr. Chairman,
What was it before? Okay, yes. Hold on. I'll give you.
In this bill also, I have to challenge something. We have given them the responsibility. I have just raised the question. And we law should be in conformity with existing laws. The bill is a proposal in front of us.
Yes.
Let us go back to, for example, the SABC Act. We have only one. We have not had of any confusion. Why are we changing it now? We have one. So we are giving the responsibility to the institution to give us one person from the Inter-Religious Council. We have it for the SABC board. So we have it here one. In the parent act, we have one. So the reason they are proposing, I don't see any justification, Mr. Chairman.
Well, let's allow him to give us the rationale.
No, Mr. Chairman, before the chairman, because we are part and parcel of the business. Mr. Chairman, we are defending our chairman now. It is our business to defend the chairman of the legislative committee now. The SLBC is not the regulatory body of the media landscape of Sierra Leone. We have the IMC, and we are making the law for the regulatory body of the media. And if we have the IMC as a whole media, initially the two leaders agreed that what is good in the paper that we have here in front of us, let us go with it. So we don't know what is the problem with us having a Muslim and a Christian. And Mr. Chairman, let us be very, and these are experts. These are very good experts. Some of them are real journalists. Some of them have been practicing journalists for years. We have Muslim radio stations now and Christian radio stations. So in that direction, Mr. Chairman, we unanimously agreed to have two representatives of the Inter-Religious Council to help us mitigate, to help us minimize, to help us massage, to help us synergize the problem into the committee. So I therefore ask that we leave it at it is. Thank you very much.
Mr. Chairman,
can I add my voice?
Mr. Chairman, it is not even clear that if you put two representatives, you will get Muslim and Christian. It's not clear. No, it's not clear. Let me come, Mr. Chairman. Let me come. If you have, we have other religions. To be very honest with you.
But those are the two main ones.
Major. So if you are now saying it's only Muslim and Christian, take into recognition that we have other religions.
Point of
order. It's very clear.
Mr. Speaker,
let me come. We have the Hindus here, the Indians. We have the Hindus here.
Mr. Speaker.
So let me
Mr.
come.
Chairman.
Mr. Chairman, on my legs. Mr. Chairman, we are trying to divide the Muslim and the Christian. By the explanation she's giving us now, we are sending sense of division. There is no division here. We know we have religious integration in this country. You can have a Muslim married to a Christian married to a Muslim, vis-a-vis. So what are we insinuating? Let us believe in their faith. It's the institution we are addressing. It's not individual perception. It is clear in the Parent Act that we are recommending for them to give us one individual who can represent the view, not of the Inter-Religious Council, but the interest to regulate this particular institution. That is my submission. We are not there to talk about religion. It's not a religion business. It's about somebody helping to regulate. Please. We are not, this whole thing is not about protecting religion business in the IMC. It's about talking about regulating the media. And they are saying it to be, because we said in the bill, there is independence of the commission. They should be independent. So what we are saying, if we are pushing for a representation, we are not talking about religion. We are talking about somebody coming from a decent institution, representing and carry the view of the people who are not involved. That's what I'm saying. So the institution is very key in this. That's my case. For the bar association, they don't normally say somebody from the bar. It's the lawyers who come together to have a representative. It's the lawyer. So in this case, if you say Muslim and Christian, it means they are going to promote ideas about the Muslim religion and the Christian religion. It's not that what we have. It's not the intent of the bill. The intent of the bill is for us to have somebody help in the regulation of this media practice. That is my submission. So let us have one conformity of the law.
Okay.
Yes, Mr. Chairman.
I'm sure, Mr. Leader, you will agree with me. You will agree with me if I were to ask the chairman of the legislative committee to give us the rationale for their proposal. No, I'm going to allow it.
Mr. Chairman.
Mr. Chairman.
We want to help the chairman because we are members.
He can help himself.
Yes, Mr. Chairman.
In this one, give him chance.
Mr. Chairman, at the committee stage, we had not honestly wanted to send 2 members from the Inter-Religious Council. We wanted to create a balance. So we wanted to have 1 member from the civil society. Then this argument ensued that who will nominate who. So that 1 member, we wanted to place him or her somewhere just to create a balance on the commission. Because remember, we've had loads of journalists on the commission. So we wanted people from other sectors of society. So it was when this argument now ensued that we cannot get somebody from CSO that we just said, well, let us add that person to the Inter-Religious Council. But even at the committee, this issue of sending 1 Christian Muslim will create a problem did erupt, and people believed in it.
Well, know that you are well-intentioned.
Mr. Chairman.
But just see the controversy that it is generating here. So do we need that provision at all?
Yes.
Mr. Chairman,
Mr. Chairman.
From what we have
in the light of what I'm seeing, I raise the question, do we keep it or we get rid of it?
We keep it. We keep it, Mr. Chairman.
Mr. Chairman.
Mr. Chairman, I think I also want to have a bite on this.
Who?
Myself.
Yes, Mr. Chairman.
Yeah.
Yes.
No, you have an interest.
Why?
Yes,
You have a personal interest.
Yes, Mr. Chairman. Mr. Chairman.
You have a personal interest.
Mr. Chairman,
Mr. Chairman.
Mr.
Chairman, I am part of the privilege.
Mr. Chairman,
Mr. Chairman, I have been over
Honorable
3
members,
times
please
now.
please calm down. Honorable Dixie Rogers, or the honorable member for conclusion, you are not present for the legislative. Mr. Speaker.
Yes.
It is. I was also at the legislative committee meet, and I listened carefully to the chairman of the committee. All what he said is correct, and that is why I want to say that I have been convinced by the leader of government business. Let me say why. No, whether there is a vote, or let me just say, what he said, what the chairman of the committee said is true. We had serious exchanges as to whether there should be 2 or 1. It was when we failed to agree on who the CSO should be, that was when we utilized the Intelligence Council as a fallback. It was a fallback. And the reason was deliberate. The members from the Fourth Estate will tell you, they wanted their member because they don't want to lose their space. And we needed to have an odd number in the board. And it was a must that we get them because their interests must be protected as well. So when we brought them in, we fought over the CSOs until there was no conclusion. Then we went for the fallback. But now, as I said, I am convinced by what the leader of government business has said, that we follow the institution and not the individuals.
No, thank you, Mr. Speaker. You cannot put our...
Mr. Chairman, I have a point of view.
Mr. Chairman, let me just come in.
Mr. Chairman, I have a point of view.
No, for morality, Mr. Chairman, we agree on the other day. If you have interest, you should not participate. So it's a reverend.
Mr. Chairman.
It's a reverend. Mr. Chairman.
In your absence, you have been given a new title, Pastor Lamina.
Mr. Chairman.
Mr. Chairman, may I be heard?
Mr. Chairman, Mr. Chairman, I intend to read the memorandum of object and reason.
No, I don't have interest.
But Mr. Chairman, are we going for a laying out ceremony? Or are we talking about regulating an industry? Those two things we need to distinguish. Are we going for laying out ceremony, or are we going to have to regulate an industry? But before you are talking about putting our request into a vote, let common knowledge prevail on this one instead of votes. Memorandum of object and reason. I have not announced the committee yet, so if you vote, whatever I move Let me come. Mr. Chairman, the object of this bill is to provide for the continuation of the Independent Media Commission, to provide for the registration and regulation of mass media institutions in Sierra Leone, and to provide for the other related matters. It is very clear, Mr. Speaker. But let me say here, I have not announced the committee yet. I know you are aware of that.
But wait a minute.
Yes, sir.
Leader of government business.
Yes.
I think I've been privileged more than once to attend service in your church.
Yes, sir, yes.
And I was pleasantly surprised when I saw the regalia.
In a straight fatigue.
What?
In a straight fatigue.
Well, you came out.
I'm a knight. I'm a lieutenant. I'm a knight. I'm a knight. So I'm not a pastor, but I'm a knight. I'm serving the people. That is how you call it. We help the church to grow. We promote the church. So that's what we do. So I am a knight. I'm a lieutenant. I have a major here, my brother. And there's another colonel here. We have them in the house. So, Mr. Chairman, I have said, that cannot take me off my religious belief. But we are not going for a layout ceremony. That is all I have, to have Muslim and Christian. But let me say this, Mr. Chairman. We are talking to you to understand the situation. You need to understand the situation. Because we are not yet announced the... So do you want... it's a reminder.
Yes, Mr. Chairman.
Mr. Chairman, only one point.
Mr. Chairman.
The composition of the committee
You've spoken far too many times.
Yeah.
Thank you,
The
Mr.
composition
Chairman.
of the committee has to be odd number.
Mr. Chairman.
Instead of 11.
I want
it's
to
10.
vehemently agree with the leader of government business on the provision that he talks about institution. But what actually we agreed at committee room 1 was to ensure that we have a civil society representative, Mr. Chairman. But to say we were not able to arrive at consensus of having a civil society, it was only because they ignored listening
to people who will give them information about civil society. We have series of civil society organizations. I can outline some of them here. Then it is now the owners of the House to take which one they will give. But let me tell you, Mr. Speaker, we cannot go along with an important information of this nature, an important bill of this nature, without the participation of civil society into its board. Mr. Chairman, we have the non-state actors in this country. It is a civil society organization. We have the Civil Society Movement Sierra Leone. It is a civil society organization. We have the Coalition of Civil Society and Human Rights Activities. It's a civil society organization. We have a plethora of civil society. So they can take one, and as long as they know the contact of that institution, the problem is solved. But the issue we discussed at Room 1 did not base on religious division, on religious division. We only focus that because the majority in the Interreligious Council is being constituted by the Christian and the Muslim, even though we have other religions. That is why we only spoke about Christian and Muslims as a fair representation. But that is not the case of that. In as much as the leader has talked about institution, then we go for the institution, Mr. Speaker.
Mr. Speaker.
Honorable AKK. No. You've spoken more than once. You've spoken more than once. SO 32.
Mr. Chairman. Mr. Chairman.
Are you a reverend too?
No, Mr. Chairman.
Yes.
I'm not a reverend.
Yes, he is.
I'm not a reverend.
Or one in the making.
Yeah. I'm a nice
He's an ordained man already.
Let me listen to Honorable Dixie Rogers. Okay. But wait a minute. You two have an interest.
No, I don't have.
Yeah, you have an interest.
Mr. Chairman, I'm just a Muslim.
Let me be heard.
And Mr. Speaker, I want to be heard also, please.
Mr. Chairman.
Yes.
No.
Let me be heard.
I wanted to give you the floor. But if I remember right, you traveled to France once, came back, and you whispered something to my ear. And I want to believe you have an interest.
No, Mr. Speaker,
Not on this specific
Mr. Speaker, I'm a fervent Muslim, but I'm not an imam.
No,
so,
not on this specific issue, but on the general content of the bill. You have an interest.
No, that's no way. I'm not going that part, Mr. Chairman.
So, okay, give me the floor.
If I give you the floor, will you help me resolve this? Outside of a vote.
I have a solution, sir. Outside vote.
Outside of a vote. Otherwise, we're heading for a vote.
Mr. Speaker.
Try to do exactly what you are expecting.
Let me hear you.
Okay. Thank you, Mr. Chairman. This issue need not be labeled like this because we have the Interreligious Council, and the Interreligious Council is being a mix-up of the various religions. We have the Muslims and we have the Christians. And even presently, the leadership of that organization is a Muslim. So they have been conducting their affairs perfectly, and there is no division amongst them. So the fact is, the seat is for them, the Interreligious Council. So there we go and sit and nominate. I think I told the line of the two leaders that we should have one seat, because we have religious tolerance. We don't have no interreligious wars or differences. we have religious tolerance. So the issue of giving 2 seats to the Interreligious Council is not normal. So it's good for us to give 1 seat, and they will sort it out. You see? Yeah, they will sort themselves out. And in fact, again, if we give this, all the ingredients, you know, when you are making a palatable sauce, the more the ingredients, the more palatable that sauce will be. So adding the CSO on board, we bring the there is no need to go into food.
Let me hear the word of wisdom. I.B. Carbo.
Here I'm talking about consistency in legislation. We have quite a lot of legislative work done here, and we have examples and precedents where the Interreligious Council was mentioned or was brought into the administration of those institutions. And yet it has always been one. Anti-corruption is one. SLBC one. And a good number of other institutions.
So let's be consistent.
Let us be consistent as members of parliament. So I think it should be one.
And the original bill proposes only 1.
Mr. Speaker.
Let me finish. Let me finish. The original bill, the proposal was for 1. This new proposal of having 2 has come from the Legislative Committee. So since it does not seem to command a consensus, I'm inclined to suggest here that we keep what is contained in the original draft.
Mr. Chairman, can I be heard on that?
Mr. Speaker. Mr. Speaker.
Since that is also consistent,
I am calling
you see, we are lawmakers.
Okay.
We are lawmakers, and I'm a great believer. I believe in the value of precedent.
That's where I was coming.
We'll be reminded of at least 2 or 3 laws that will pass in this House that have the Interreligious Council. I want us to avoid a vote on this.
No, we are not voting.
Mr. Speaker.
For some of us who were in the committee, there is a provision for bringing members who are not originally in the list. They can adopt members when they are issued. I think the leaders are making sense out of it now. Now that we've understood where they are coming from, if there is an issue, let's say, for example, the person on the board is a Christian and there is an issue related to Muslims, they can co-opt somebody into the board and get it so. So we agree with the law make provision.
Mr. Speaker. Mr. Chairman. Can you hear me, please?
Mr. Chairman,
please.
Can I be heard?
Mr. Chairman.
Okay, that's your last contribution on this. Take your seat.
Mr. Chairman, please.
Let me listen to
AKK, your last contribution for today.
Yes, Mr. Speaker, thank you very much. Mr. Chairman, a few minutes ago you said we are lawmakers and we should not be seen as lawmakers dividing Interreligious Council. Because no sooner we start talking about 2, they will not be in a position to take 1 Muslim, 1 Christian. There will be, the lawmakers will be divided in a very Interreligious Council. We only have 1 Interreligious Council.
And when we should be talking about cohesion and integration.
Exactly, Mr. Chairman. So, Good. Mr. Chairman, I want to support not only your idea, but the ideas of the various leaders that we have 1 Interreligious Council. Having said that, Mr. Chairman, like my honorable doctor said, the civil society is very important in every stake of this country. Therefore, I'm still of the opinion that having civil society on that board will make us a lot of good. Because now we've agreed that we're only going to have one representative from the Religious Council, making the number to 10. We still need to have an odd number. Therefore, Mr. Chairman, because the civil society in this country is so important and pivotal to the democracy of this country, I'm suggesting that we still have one civil society to add up to the number to 11, so we can have odd number. Thank you.
Okay, you wanted the floor.
Yes, Mr. Speaker, Mr. Chairman, the reason why we, as the chairman for the legislative committee said, the reason why we put 2 members from the Interreligious Council was because we were unable to identify who will nominate the civil society organization that will be representing the CSOs. And in this way, we can still...
But that was not your business.
No, we cannot select by ourselves, and they don't have an umbrella body that will regulate the CSOs.
Yes, they do. Listen, honorable member. Our attention has been drawn to the fact that there is existing legislation which makes provision for a representative from the Interreligious Council.
Well, I agree.
Okay?
I quite agree with you.
And
sir.
they've had no difficulty providing a representative. Why don't we stick to that?
I agree, we can stick to that. But who will nominate the civil society?
That is their business. That is their business. So we go for one. Let's go back to the original.
If we are
The
making
consensus is we keep what is in the original bill. Please do.
Mr. Chairman, based on all of the arguments on this issue, I want to move that we go back to the original bill by having one representative from the Interreligious Council.
Any seconder?
I so second, Mr. Speaker.
Mr. Speaker. Mr. Chairman, I so second.
I'm not going to ask for a counter motion on this one. All in favor, say aye. Those against, say nay. The ayes have it.
Mr. Chairman, so the one now we have for the civil society.
What?
We have one rep from civil society who are media related. We ask the minister to give us a lead on that.
That's a brand new one.
Yes, that's the reason we separated the two.
What?
That's the reason we asked for the separation. Let's have one and have civil society incorporated into the commission. Yes. So now I will
I'm going by the report in front of the House. This is entirely new.
Yeah, it's new. That's what I proposed during the recommendation. I proposed for us to have one. Okay? In the debate, I mentioned that one also. I was expecting them to carry that one.
I thought the Interreligious Council.
Against the report. We are not.
We are just trying
going
to...
with the report, Mr. Speaker.
Okay.
We are not going against the report. What we have just dealt with is as to whether the Interreligious Council should get one or two. We're past that. The next step now is to get the civil society incorporated so that the odd number will be completed.
Why does it say that in the report?
No, it's not. That's what the House is doing. This is for the House, Mr. Speaker, Mr. Chairman. That's for the House.
The whole House, Mr. Speaker. So what are you coming me?
We are in concurrence with the leader.
So can we? So I ask that since we are inserting that one now, I want us to have the minister to have his say on that, to have a civil society, because in the debate it said Interreligious Council. Now we have convinced the House that we can get one member from the Interreligious Council and one from the civil society. So I want us to have the minister to say something to us.
Mr. Minister, are you comfortable with that?
Use the mic, sir.
Honorable Speaker, I'm absolutely comfortable with that.
So we'll have one representative. That will be the new age.
Yes. But we need a minister to give us, because there was an argument, where do we get civil society? People are saying Slango, they said they have their umbrella. So say, no. It's in the provision. It's a provision. It's a recommendation. It's in the provision. You should know where we go to get the civil society. Whether from Slango, how it's nominated, or from the executive. We need to be clear on that. Point of order.
And what about if the minister
So, we said one representative of the ministry nominated by the minister. And if you are going to talk about the civil society, we should be uniformity what we have. So what we are saying, we want to paraphrase that. We are not saying we have to take it from Slango. There was an argument. Can we have a body that can give us the nominee from civil society that are media related, not all type of civil society?
Mr. Chairman.
Huh?
Mr. Chairman again.
Yeah, it's a consultation we are doing now.
Mr. Chairman again.
I like that qualification. Media related.
Media related. That's what I said
Can we
from
put
the
that
beginning.
in?
Mr. Chairman again.
Are you comfortable with that?
Media related.
Mr. Chairman
Yes, Honorable
again.
Speaker. That is very important, media related. We do not also want to circumscribe the powers of the presidency to such an extent that we literally dictate to him who we appoint.
Let the minister
So, yes,
do nomination.
Nominated by the minister for approval.
Mr. Chairman again. I want to counter. I told you I am not a Division 3 student while I was in the university. Some of you, most of you there are Division 3 students. Mr. Chairman, please. Let me make this submission. May I be heard, Mr. Chairman? The issue of civil society, it will be difficult for government to pick a civil society person to represent in a board. Government and civil society have two different operations.
We've qualified it though. We said a CSO which is media related. We've qualified it.
Mr. Chairman, it is only because I don't want to be hard. But the fact of the matter is,
aren't you being hard now?
Yes, we have series of registered civil society organizations in this country.
Mr. Speaker, I'm standing on SO 32. Mr. Speaker, I'm standing on SO 32.
Which one? Which paragraph?
SO 32.8. The Honorable Member, in my opinion, and in the opinion of a lot of us here, I believe the Honorable Member that just spoke has used a derogatory statement on us by saying most of us here are Division 3 students. We are Division 3 students. I believe that statement should be withdrawn because I'm not sure if he can point any MP here that was in Division 3.
Your point is noted.
No, it's not you. I was talking to the speaker. I was talking to the speaker. I think I moved that he withdraw that statement. Most of us are A students here. No, I'm standing on a point of order. I'm addressing the chairman.
Dr. Kasai Ali, if you go withdraw Dandy.
Do the honorable thing now.
Thank you, Mr. Speaker. But, Mr. Speaker,
there is no but.
Mr. Speaker, I have used the word noted.
No.
It implies.
No. Do the honorable thing, please.
I do rescind.
Thank you. Now, let's make progress. There is another proposal here from the committee, H. A representative of the Sierra Leone Association of Journalists, nominated by the Sierra Leone Association of Journalists.
Yeah, Mr. Chairman, I don't have a problem with that. Why? That provision is clear to us. That one, that is another odd number. But let me, we need order in the house.
Please, come.
Mr. I want to make my point before we come to you. It's very important, sir.
On this one?
Yes, very important.
Okay,
if we want to have SLAJ, to do their nomination, Honorable Leader, if we want to have SLAJ to have the nomination, let us also look into section 3, clause 3 rather, subclause B, subclause C, subclause D. And the B. And if we come to subclause 6, independent of the commission, this thing is geared towards regulating the media. And we are talking about giving SLAJ a whole lot of latitude. People are going to arbitrate. We are giving SLAJ a whole lot of latitude. They nominate this, check the composition. Can we say this commission is going to be independent? Can we say? Number has to do. If they have the interest of SLAJ, 2 nominated from SLAJ, the other 2 nominated from SLAJ, the other 2 nominated from SLAJ, just think about the human aspect of it. For me, let me learn, please. It's just for us to have the clarification. I'm not against us adding SLAJ. That's I'm 100% in favor. But I just want us in line with the independence of the commission, clause 6. So let's be very clear from the chairman we need, because he said, let us accept them. Now we are inserting nominee from SLAJ. So that is my submission. I just want us to go in line with clause 6 of the bill.
Mr. Chairman. Mr. Chairman, sir. Will not sleep. Mr. Chairman, sir. Reverend, just give me 1 minute. Thank you very much. Mr. Chairman, again, as I said, I want us to make progress. We have just finished with the civil society group. The civil society is there because we want to make the number odd. If we take out this large nominee, we will also have to take out the civil society, and it will not benefit us. Because we need an odd number. But also again, in the committee, the chairman will tell you, Mr. Chairman, we were convinced by SLAJ, because of past experience, this nominee is absolutely relevant in the commission, Mr. Leader. We are convinced, the chairman will tell you, the nominee from SLAJ that will represent their interest.
You don't get me clear. It's not that I'm challenging. I say I'm 100% in favor to have SLAJ in the commission, on the board, on the commission. What I'm challenging is in line with clause 6 in the bill, the independence of the commission. I'm questioning now. No, the number, no, if you check, I think you need to come inside. You need. Let me now go. I don't know if you understand what I'm pushing. Okay, fine. So let me just come. For clause 3, sub B, Mr. Chairman, page 4. You see, 2 experts in the field of electronic journalism, one of whom shall be a woman nominated by the Sierra Leone Association of Journalists. 2. You have 2 experts in the field of print journalism nominated by the Sierra Leone Association of Journalists. That goes to 4. 1 expert in the field of information and technology nominated by the Sierra Leone Association of Journalists. I'm not saying I'm against. I just want to be convinced by the committee. Why do we need to have them nominated by //? And in tandem with section 6, in clause 6, clause 6, because all of that coming from the media institution. Clause 6 talking about the independence of the commission. And this particular institution gears towards regulating the media. And these nominees and the commission is going to be charged with responsibility in regulating the media. For fairness, all of them will have 6 coming from SLAJ. 6. So if they gang, these are their nominees. If one of them are involved in an offense, how can we combat that one? I want to be convinced in line with clause 6.
And let me ask a question. I'm a great respecter of SLAJ. Let me take the cue from the leader of government business. I'm a great respecter of SLAJ. But is it fair? Is it reasonable that SLAJ should dominate the commission the way it is being proposed?
Mr. Chairman.
I know the leadership of SLAJ is here, but they should be asking themselves, if, for example, there is a complaint against SLAJ itself, will this not lead to a situation where they will become a judge in their own cause? Because they will constitute the majority of the members of the board.
Mr. Chair, please. Mr. Chairman.
Mr. Chairman.
No, this is a matter of principle here.
Mr. Chairman.
Mr. Chairman.
Mr. Minister, let me hear you.
Thank you, Right Honorable Speaker, honorable members, colleagues. In the current arrangement, we have dedicated persons on the Independent Media Commission, not because they are SLAJ members per se, but because of their expertise. That is why they are there. The number you have there is not chosen on the floor by SLAJ to represent them. That is why it is their designated and dedicated representatives that go back to them and represent them on the commission. So my proposal is that this bill should not make them worse off. If anything, it should make them better off. Thank you.
Mr. Minister.
Mr. Chairman. Mr. Chairman.
Yes.
Mr. Chairman.
Mr. Chairman, when you look at clause 6, we are asking for an independence of the IMC. And when you go into the composition, we have SLAJ providing almost all of the board members. Mr. Chairman, honorable members, D, one expert in the field of information communication and technology nominated by the Sierra Leone Association of Journalists. Why? Exactly, why SLAJ? So SLAJ is now going to dominate the entire. Today we have right people now manning SLAJ. Let's assume in future elections of SLAJ, you have people who are so partisan, who are people who are not professionals as these people are. They will now be recommending to the commission people of like minds. At the end of the day, they will now claim independence and they will now muzzle everybody in the public.
Mr. Chairman.
Mr. Chairman.
Let's listen to the paramount chief.
Thank you, Mr. Chairman. When I read this, we are regulating mass media. And SLAJ is the mass media. It's composed of the mass media. It is very hard for us, when you look at the composition, they form more than even 60% of the entire composition of the commission. So for me, we are just, let us not legislate for now. Let us legislate for the entire future of Sierra Leone and the issue of journalism. So, but my argument here as Member of Parliament the people, we are now on the third, on the committee stage. And in the committee stage, you cannot just argue. Let's come up with recommendations, resolutions, and position papers, position. Like if, for example here, they said 2 legal experts in the field of electronic journalism, one of whom shall be a woman, nominated by the Sierra Leone Association of Journalists. Then you go to C, 2 experts in the field of print journalism, nominated by the Sierra Leone Association of Journalists. D, 1 expert in the field of information, communication, and technology, nominated by the Sierra Leone Association of Journalists. So it is, that one cannot hold. It is not a legislation because it's going to be self-regulatory. They will come up and win the election. You see? So my suggestion is that the minister, let us put the burden on the minister for them to nominate people in there. And those people who come here, we have to agree on them that they should be approved by Parliament. But we cannot just come in and say we give. We have given too much. We repeal a law that has disturbed the entire nation in terms of journalism, reporting, association. That has been done. Now, let us regulate something that will be a future guidance for the entire nation of Sierra Leone. We cannot just say everything will give SLAG. I'm not against SLAG, but if you are going to regulate, you come up with that. Then everybody, to say we nominate. If I nominate you into anything, you have to go in and represent me. You have to. Next time, if you go in there and bring in different argument, I will not nominate you. You see? So my recommendations here, when in most of what we are doing in this country, either the president nominates or the minister nominates. So if we don't want the minister, then the president should give us nomination for these members to go into the commission. That has been the case.
Mr. Chairman, may I be heard as the chairman of the committee? Mr. Chairman, at committee level, all of these arguments came up. And I must say, because we invited the public, they were able to convince us, point one, to say these nominees are not necessarily going to be SLAG members. That was why they pushed for one of their kind to be nominated. Because if these experts were going to be SLAG members, there would have been no need for them to push for them to have a slot. And added to that, Mr. Chairman, SLAG is highly desirous to move towards...
Point of order, Chairman. For the sake of time, I concede, Mr. Chairman. We are now convinced. Yeah? So, thank you. There's another one.
Wait a minute.
No, Mr. Chairman.
Wait a minute.
Mr. Leader.
No,
Mr.
Leader.
Chairman.
Leader.
I have conceded.
Mr. Chairman.
Mr. Chairman, I raised the issue.
No, it
so
doesn't
if
matter.
I conceded, then
No. Mr. Chairman.
I raised the issue.
No.
Mr. Leader.
No.
You are not the only one arguing.
It's already in my record. I was going to raise it. But it doesn't mean because you raised it.
Okay,
So therefore, if you are convinced...
On my own side, I've conceded.
No, but you concede.
Okay.
I'm not conceding.
Okay, one way for my
Please. Yes.
The great man.
Yes.
The great man.
Yes. You concede.
I want us to be on the same page.
No, well, no, yeah, but no, you cannot overrule.
No,
you are overruling.
Mr. Chairman, for the sake of my crew, I wait.
I was on elect on chairmanship
Yes,
when the leader... Mr. Chairman, members that we invited, I must say, were able to convince us as to why we should leave those nominations in the hands of, as it were in the parent bill. Firstly, those experts, they were able to tell us that we are not necessarily going to be SLAGE members. These will be experts in those different areas that we advise on the commission. These will be professionals that we advise on the commission. If you look at our report, we even went further because we wanted gender representation to ensure that we have 3 women on the commission, because the legal professional body will be sending 2 representatives, one of which is a woman. There was another suggestion for 1 woman, so we added another woman under the ambit. Mr. Chairman, honorable members, the rationale for that also is SLAGE is trying to move towards self-regulation. When somebody desires to be responsible, that I can handle myself in a responsible form, you give it to them by phases. If that is what they have come to do, and it's in the Parent Act, we deem it necessary to start giving them that free hand as we did in the report. We don't want to be seen as if we are taking away each and everything that they are asking for. If we go through the report, there are areas where we actually made sure our voices as members of parliament was heard much more against their wish. When we get there, you see it glaringly. But the leader of opposition was there. Several people participated in this. I agree the entire house was not there. But we came to the consensus that we leave those nominations to them. Even when they say, well, if you nominate somebody, if his time is coming to a close, he will tend to support you. We looked at it that those people that they will be nominating will also be going through other phases. So as a chairman, Mr. Speaker, I think we are not belaboring the point. It's a sensitive point, but that was the rationale, that they want to move towards self-regulation. They want to arrange the fears of the public, that they are going to be responsible enough, that they were not merely going there or nominating these people that will be seeking employment. They will be seeking people that will seek the interest of the general populace that we are representing. That was the assurance that they gave us.
I hear you. I hear you, Mr. Chair.
Mr. Chairman.
Oh, yes, let me listen to dear speaker, because I have 1 or 2 troubling questions here.
Mr. Chairman, I submit that the journalists are being magnanimous, allowing outsiders to join their commission or their regulatory body. Mr. Chairman, the best people to regulate professionals are the professionals themselves. You can't get outsiders to come and regulate lawyers, for example, or you get outsiders to come and regulate doctors. It is the lawyers or the doctors themselves. The mere fact that they have allowed outsiders to join their commission, I think it's fair enough, Mr. Chairman. Let's allow that.
Yes, Mr. Chairman. Mr. Chairman.
Yes, Chief.
When you talk of regulation, they can come up with their own regulations that they command themselves. The Sierra Leone Bar Association regulates itself, but they don't legalize in national issues. There is a law in Sierra Leone that governs the actions of lawyers. There is a law in Sierra Leone that governs the performance of doctors. They have that. No, they can go, the court, they can be charged. They should not. I'm not denying they have their association. I am sure they have regulated themselves. But I will prefer for us to say we nominate 2 SLAGE members to be members of the commission. We give them that. 2. They can come in now and nominate. But for example, I looked at it, Mr. Chairman. The bill, if you go to the preliminaries, there is nothing that defines who is an expert. If we bring in all these, Mr. Chairman and Mr. Minister, you put in
legal expert. What do you define to be an expert? There is nothing in the bill. First of all, I recorded it yesterday. There is nothing in the bill to show who is an expert. Whom do we define to be an expert? For me, if we want to include an expert, let us bring in independent people like Frabe Collect, the lecturers from the mass communication. Mass communication, we can call them experts because they are the lecturers that lecture the journalists, you know. But we cannot just come in and say everything, sludge, then there is nothing for us to regulate. So,
Mr. Chairman. I really want to pose a question for the consideration of all of us. Honorable members, we should not lose sight of one important matter. What we're doing presently has a direct bearing to what we're going to do immediately we conclude the debate on this particular bill, which is the repeal of Part 5 of the Public Order Act. And I think the consensus in this House was that this House owes a duty to the general public to ensure that whilst we agree to repeal that part of the Public Order Act, we should at the same time enact legislation that will protect the public, especially where reputational damage is concerned. Now, are we taking care of that by creating a commission that is going to be completely dominated by sludge? No, madam, I know where you are coming from.
Mr. Chairman,
I know exactly where you are coming from.
May I be heard, Mr. Chairman?
Have we adequately protected the public interest in this one?
No.
No, please. Let's not be emotional about this.
Thank you.
Let's not be emotional.
Mr. Chairman.
We are solving one problem. Let's not, at the same time, create another.
Yes, Mr. Speaker, please.
I want to be convinced that what we are doing now is protective of the public interest, is protective of individual reputations. Let me listen to the leader of opposition.
Thank you very much, Mr. Chairman. Mr. Chairman, you posed the question, and the question is a salient one. But first, before saying anything, may I say that I agree totally with the Deputy Speaker. Totally. Honorable Paramount Chief from Tonkolili was comparing sludge to statutory bodies. Sludge is an association, whereas the IMC is going to be a statutory body. So their interest, as far as the spirit of this bill is concerned, that is moving towards self-regulation, which is the spirit of the bill, should not keep them out of the commission itself. That is one. But answering to your question, Mr. Speaker, I totally agree with you. I'm coming to that now. Mr. Chairman, I'm coming to that. This bill, when enacted, with whatever we'll do, listening to the minister carefully last week, and knowing what I know as a legal practitioner, Mr. Speaker, this bill is not what is going to be the safeguard for myself, you, or the ordinary man and woman in the street. It is not the document. The minister was very clear last Thursday. And he was also very clear on Monday when we met at committee room number 1, that already without this document, there are sufficient civil safeguards. The minister was very, very clear. It is left for us to utilize the civil outfit. This is going to add value to those safeguards, but this is not going to be a sufficient safeguard. I take somebody to the IMC, your radio station or paper is suspended or banned. That is not going to be sufficient. I will need compensation in damages, and I can only get that when I go to the court, not to the IMC.
But you know how long it will take you in the court?
Yes, I know. But Mr. Speaker, you know, Mr.
Reply.
Chairman. No, Kanagba Osanka.
Yes, please.
Take your seat.
No, I'm just taking...
Leader of the opposition, I'll be very interested to see how you balance the need for the professionals to be, or slash, to dominate the membership of the commission and the protection that the ordinary person in the street deserves to have.
Thank you again, Mr. Chairman. We just heard from the minister a few minutes ago that SLAJ will not be dominating. That SLAJ will not be dominating.
If you take the original bill,
I have it with me.
They will have.
I don't want to
they
read
will
all
be nominating 6 out of 11.
We don't want to talk about practice. This is the practice is.
No, they will be nominating 6 out of 11.
Those that will be nominated,
including the chairman.
But those that will be nominated will be subject to the approval of His Excellency, who will eventually be giving them a letter of appointment to face this House. They are not going to be absolute. They will not be absolute. All these nominees will be coming through Parliament. Mr. Speaker, in any case, as members of Parliament, we are here, we are following the queue, we are listening to the questions, but having listened to the minister, I believe that as a House, it is incumbent upon us to keep this very representation.
Mr. Chairman.
Mr. Chairman, please.
Mr. Chairman.
Just a cue from the leader of the opposition. We don't want to stay too long on this. Mr. Chairman, if you go to page 7, clause 8, clause 8 is very clear. Not because you are going to be nominated by SLAJ, so you can just do things the way you feel like. I've considered long ago because I've read much on it now. The Commission shall make regulations governing the conduct of members of the Commission in relation to issues of conflict of interest and misconduct of members in respect of their duties under this Act as deemed it fit. So, Mr. Speaker, that answers the question.
Where are you reading from?
Page 7, go to page 7, clause 8, regulations of the Commission. That the Commission shall make regulations governing the conduct of members of the Commission. That is very key in this one. I just want to toe the line of my colleague on the other side and look at
page 7.
Page 7. Page 7, subsection, clause 8. Page 7. Yes. And you know the minister is the one that's going to make the regulation. You know that very well. And also, even SLAJ themselves, if you go to, they are going to do what we call, if you go to page 9 again, G, there is going to be establish, monitor, and enforce a media code of practice throughout Sierra Leone in consultation with the Sierra Leone Association of Journalists. So all these are things we put together as a safeguard for the public. So it's not like we are giving them pro bono business so that they can act on the board, do things the way it is. And those regulations are going to come from the minister himself. The ones are going to come from SLAJ. So that is very clear. So to say because you have been nominated by SLAJ so you can do things the way you feel and you don't disclose your interest, it clearly will be explained by the regulations that's going to come up.
I just want to be satisfied that we know what we're doing.
Yeah, we know.
And the public is adequately protected here.
Yeah, that is the reason I've read this provision, so the public can know that they are protected. That is the reason we said the regulations are going to be done by the minister.
Let me pose a question because I have looked hard and I haven't seen it. Apart from the chairman, of the commission, who will be approved by Parliament. Where does it say? Where? Oh, in the report, because it's not in the original. Very well. Okay.
Chairman, in their forms, they will check for the expert qualification during the interview. I'm the chairman of the appointment committee. I will take note of that. We will check if you are an expert in that field.
Chairman.
Mr. Speaker, Mr. Chairman.
Yes, Mr. Chairman.
I have heard the two leaders. Talk now. The two leaders have spoken a lot about this, but they are only quoting what satisfies them. Go to section 12.1. Section 12.1, page 9. The commission shall be responsible for the implementation and enforcement of the act and regulations made under it. So if you are going to dominate, then you are just going to enforce and regulate what fits you. The IMC should be an independent body that guarantees the freedom of SLAJ or of all journalists. Let us just don't even talk about SLAJ. There are people who don't want to even join. There are people who can print, write, document. Under what we are now repealing, the 1965, Part 5, suppresses everybody. Not only SLAJ, not only newspapers, even meetings. We, the paramount chiefs, we are given great powers in that Part 5. You cannot hold a meeting without telling a paramount chief or the police under that. But we found we don't even implement that law because it's ridiculous. We don't regulate it. We don't want it. We don't want it. Because I don't want to affect it. I cannot stop any political party from holding a meeting in my chiefdom. Never ever. You, that party, should not even ask that question. It is SLPP that got to ask me that question. You know it very well. I was your chairman. If he asked me that question, you see, so in fact, the SLPP should ask me that question. I'm not you. I'm not you.
Honorable.
No, so, Mr. Speaker.
Mr. Chairman, this is a true confession.
Yeah, no, yes. Yes. So if any APC stands up here and asks me where I belong, then they don't know where they are.
Yes, sir, Mr. Speaker.
No, but
no, I'm not yet done. So section 12.1 is what, look, I'm not, when we send into legislative committee, it's for them to look. But I am also going to look, the law allows me, Parliament allows me, after we've gone through what they recommended, if they recommended something that I agree with, I will keep quiet. But if they recommend something, it doesn't mean the legislative committee has the final say in any bill.
Okay, no.
Yes,
Mr. Speaker.
May I be heard?
No. Let me try.
Please.
Can I try?
So, I will not
allow me to summarize the position as I see it, Chief, so that we can make progress.
Mr. Chairman, I think
No, please, take your seats. Take your seats. Honorable members, let us agree on the following. One, that there is complete unanimity in this House for the repeal of the Public Order Act, Part 5. No question about that. Number two, there is also complete unanimity that the public needs safeguards and protection by strengthening the IMC. It may not be perfect now, but it is better than the IMC Act of 2000. Let's agree on that. It is certainly a marked difference from 2000 IMC Act. So if you are satisfied that this is inching their way towards self-regulation to allow them to dominate the commission, I have no quarrel with that. That being the case, let's proceed.
Mr. Chairman.
Actually, he hasn't ruled yet. Oh.
So we have a new H, which is a representative of SLAJ itself. And then the one that the representative of the CSO will be I. Am I correct? Am I right, Mr. Chairman? And therefore, what's the total number of?
Plus the chairman, 14.
13.
Plus the chairman, 14. 13. 1-3 plus the chairman, 13. Look at the report.
Yeah. Yeah. My attention has just been drawn to the identity of the CSO. Do we need that?
No, Mr. Speaker.
The minister? Very well. Okay then. Page 5. Page 5.
Mr. Speaker. Mr. Chairman. Yes, Naime Kawaii-san. On that matter. On that matter. Mr. Speaker.
You have something new on page 5.
Yes, on the chairmanship.
Yes.
I raised it twice when the committee room won, and for the record, I also want this House to know that when it comes to the chairman, they say the person, and I think I agree with the minister, we had a consensus on that we want the word, the person should be a Sierra Leonean, let it be specific. Let the word Sierra Leonean be added, because we are opening up the media landscape. The 10 years could be anybody, and the word is a media practitioner. It could be a Liberian who has been in Sierra Leone for 10 years practicing with us. And we want to safeguard our institutions. So I asked the chairman...
I thought that was a given.
Sir?
I thought that was a given. That was...
It was not...
Mr. Chairman, that was raised and it was defeated. It was the point that he's raising. It was raised. The leader was there because we think once you say the person, we all know naturally the chairman will be a Sierra Leonean, that we needn't add the word the person should be a Sierra Leonean and should be. So that issue was raised at committee stage and it was defeated.
No, but normally, if you come to parliament, you just have to be Australian. You know, it's going to pass through parliament. No.
Mr. Leader.
I don't think whether this parliament has ever approved a foreigner for a national position. Certain things are implied. The chairman would have to come to parliament. So it is implied that the chairman would naturally be a Sierra Leonean.
I agree with you, but is there any crime to include it in the law? Is there any crime?
Yes, Mr. Chairman.
Let's be
Mr. Chairman.
We have never heard that one, describing somebody say, you have to be a Sierra Leonean. No, it's implicit. That if, is it?
Mr. Chairman.
Who? The what? The director? Who's director? But we are not changing that. But they don't come to parliament. I said parliament. I'm talking about those who pass through parliament. Parliamentary approval, sir. All board chairmen who are going through parliament, commissioners. It's not possible because we look at the intent of that appointment. It's not possible, sir. You pass through parliament and giving a foreigner in that position. It's not possible, honorable. With all due respect, it's not possible. Pass through parliament, appointment committee.
Mr. Chairman.
No, just tell me one commission. We are commission. Because it's not in line with the other chairmen that we have passed through parliament. It's just not in line.
Chairman.
Yeah, Mr. Chairman.
We have agreed.
Hold on a minute, Chief.
We have agreed that adding the words Sierra Leonean is not fatal. We have agreed. And the minister himself is not averse. But that is not the point. The point I want to make is, it is deliberately stated in the Constitution that for you to run for the office of Parliament, it is clearly spelled that you must be a Sierra Leonean. It is deliberate. Let us agree. I don't have any position on this, but if the minister can tell us what he prefers and that we can be guaranteed, then let us take a cue from him. But there are certain instances when you deal with business, like you have the Sierra Leone Indigenous Business Association. It is different from the importers and exporters, where foreigners have served as leaders. The importers and exporters, foreigners have served as leaders. So again, as I said in the Constitution, for you to run for Parliament, it is clearly spelled that you have to be a Sierra Leonean. So if it is not fatal, we could have it. If it is not.
I will only add my word as chairman, and for us to look at the context and uniformity. For all the commissions we have passed, we say the poor sing. There is no commission that we have passed in this house wherein we went forward to qualify that the person must be a Sierra Leonean. We can go back and look at the archives. But if we want to start it with this one, that there is always a first time, but when these things come up, we Google and see whether there has been a precedent to that. And added to it, we have said that person will be coming to the House of Parliament of Sierra Leone for approval. I have not seen a precedent where a commissioner, a chairman, a chief justice has come to this house who is a foreigner to be approved by the House of Parliament of Sierra Leone.
But Mr. Chairman,
Mr.
Chairman,
yes, Mr. Speaker.
Is it not the intention that we are creating an environment for journalism to graduate to a professional body?
That is the intention.
Hmm?
That is the intention, Mr. Speaker.
And obviously, if it becomes one, it should not necessarily be confined to Sierra Leoneans alone.
I agree with you. I agree with you.
You know, West African, ECOWAS, for example, has a lot of protocols that give other citizens of ECOWAS the right to come and establish themselves here.
Much obliged.
Hmm?
Yes, Mr. Speaker.
And become members of SLAG or similar professional bodies.
Yes, Mr. Speaker.
So,
Mr. Speaker.
If you want, one, to professionalize this, and number two, you want to open it to investment from people with good capital, then obviously you must be flexible here. You have to allow, other people to come and participate.
Okay, Mr. Speaker, sir. Mr. Chairman.
As I said, I have no issue that has to do with Mr. Jallo. Please give me 1 minute. Because I don't want us to be wasting time on issues we don't need to waste time on. Mr. Chairman. Again, what we are opening up, Mr. Minister, What we are opening up is the media space, not the regulatory space. The IMC Act deals with the regulatory space. We want to use this as an opportunity in opening up the media. But those who will be serving here are going to be Sierra Leoneans. As a parliament, we will make sure those who come before us, we scrutinize them.
But I've heard it's a time without number that by passing this IMC and getting rid of the amending the Public Order Act, you are in fact opening the space to foreign investment and allow the media to grow and prosper. So how can you reconcile that and also being too restrictive and leaving it only to...
Mr. Speaker, sir, please, if I may
Let
comment.
me listen to you.
Yeah, thank you very much, sir. Mr. Speaker, sir, first of all, my elder brother on the other side of the aisle, the leader of the opposition, Honorable Cherry Coco, is one of my greatest admirers in this House, Mr. Speaker. But as a point of correction, Mr. Speaker, I've just listened, Mr. Chairman, sorry, sir, we're a bit complicated here, speakership and chairmanship. If I've listened to him just now, it's just a point of correction to him. The minister seated in front of us there is appointed by the president. He is obliged in presenting his matter to the government. But we are elected representing the people. So for the leader on the other side to say he has given the option to the minister to choose as to which part of the bill we will choose, I disagree on that. But let's continue. No, I'm coming, sir. I'm coming, sir. You've spoken. I've never intervened, sir. Please. This is a parliamentary debate. Let us debate, please. Let us debate. Mr. Speaker, sir. Mr. Chairman, sir, please. Mr. Chairman, we've spent time from 9 o'clock in the morning on this issue. I'm coming, sir. Please allow me to land, please.
Mr. Chairman, point of order.
Parliamentary right. Allow me to
Mr.
land.
Chairman, point of order.
Now,
point of order. Yes. He 34. He needs to tell us what is the objections he is talking about.
Mr.
We need to have reference.
Mr. Leader,
no.
I'm not objecting.
No, sit down, please. Sit down. We are talking about the bill. We are
Mr.
going clause by
Chairman, point of
clause.
order.
So let him tell us what points he raising in the bill. Direct us. We are not a generality. He made reference to what you are discussing. You should make reference to what is under discussion.
Thank you, sir. Well, allow me to land.
Mr. Speaker, if you don't make reference under this point under discussion, we ask you to make a ruling on that. We are on a committee stage. Let us go clause by clause, not what you don't feel like saying.
And we're at page 5.
I rise on SO 34 just for the edification of new members of this House, those who do not know, including my younger brother. No, my younger brother Jallo. Mr. Chairman, it is good for all members of parliament to know this, that the bill we are discussing is a government bill. It's not a private bill. No, let me explain to you. Please, Mr. Jallo, Honorable Jallo, you and others need to know this. The minister has a huge voice in this House today because he's piloting the bill.
Yeah.
He took it to cabinet. He convinced cabinet for the bill to be here. So even us members of parliament, when we are in doubt, we need clarity from the minister. He either do it directly or through the leader of government business. But that is why he's here. So whenever we have an issue that's not clear, we'll be calling on the minister to assist us. Thank you.
And by the way, Honorable Jallo, please take note.
Yes, sir. I do, sir.
You are at liberty to come with private members' bills.
Thank you, sir. I know, sir. But being that, Mr. Speaker, it's rather unfortunate I was never allowed to land my case. But since that, I don't want to interrupt the minister and the cabinet. I'm sorry, sir. Thank you.
Mr. Chairman.
Let's make progress.
Mr. Chairman. Mr. Chairman.
Could you please catch my eye? Could your eye please catch me, Mr. Chairman? Yes, Mr. Chairman.
We're on page 5.
Yeah, page 5. That's, yeah. Mr.
Yeah.
Chairman, page 5.
Uh-huh.
Mr. Chairman, I'm just inclined to believe that.
Order. Yes.
Mr. Chairman, for the edification of Mr. Jallo also, is supposed to know that the minister is the principal advisor to His Excellency the President. Mr. Chairman, I think we are still on page 5 with the chairmanship. I notice here that the chairman shall be a person with proven experience as a media practitioner or a legal practitioner qualified to hold.
No.
Yes,
No. It's been, there is a proposed amendment to that.
That's a proposed amendment. I think I have an organ with it. The organ here is realize that media practitioners are in the IMC, and the belief I hold here is I always see the uninitiated initiating another uninitiated. On that note, we actually recommend that media business, IMC business, chairmanship, be left in the hands of media practitioners rather than alternating it the or. I have a problem with the or. Alternating it with a legal practitioner.
It's out.
That's a business.
Let me refer you to the report of the chairman of the Legislative Committee.
Mm-hmm.
He's proposing that provision be amended.
All right. That media business.
So look at the amendment they are proposing, please.
Okay.
It's on page 3, at the very top.
Page 3.
And I don't think we have any difficulty with that, do we? No. Huh? No. Good. Shall we then make progress?
Noted, Mr. Chairman.
Thank you.
Mr. Chairman, I am still waiting on your ruling on this, sir.
On which one?
On the one of adding the Sierra Leonean to this chairmanship.
No. I thought we got over that.
No, we have not. You've not made a ruling, Mr. Chairman.
Did you put a motion before the House?
Well, the other things we deliberated on were not a motion, but you made rulings on how it goes.
Are you sure you've canvassed opinion?
If you want me to move a motion, I will.
Is there a consensus for that? Is there a consensus for that? You want to put her in the form of a motion?
Why not? My conscience. It's my conscience, Mr. Speaker.
But they said, I'm told you raised this at committee level.
I think that's the reason why the leader of the opposition asked the minister for us to know his views. So let the minister tell us his views, whether Sierra Leone is to be inserted or it remains as it is, then we can move from there.
Okay, yeah, Mr. Minister, guide us.
Honorable Speaker, Honorable Chairman, sorry, we keep conflating it.
Don't worry.
Yeah, so we have a situation here. This is an absolutely progressive legislation we are about passing today. I clearly understand the spirit of nationalism. I would also want a Sierra Leonean any day to lead the commission. But inserting it there is going to defeat the purpose. We want to open up, we want to join other progressive nations in the world. I'm sure each and every one of us would want our other Sierra Leoneans in other countries to access opportunities, whatever they may be. So beginning to make it very restrictive will be counterproductive. Yes, let it stay as it is. Thank you.
Having listened or heard the minister, what do you have to say, Mr. Honorable Okeke?
Mr. Speaker.
Oh, you have a helper here?
No, just for the records. Because our understanding is different from what the minister is actually saying now. I think for the records, according to the minister, it is even possible for a non-Sierra Leonean to be a chairman. That's what he's saying. He says, let us open up. That's what it implies. That there's provision for it to be open. We cannot limit ourselves. That's what the minister is purporting.
And you want it closed?
Yes, it has to be closed.
Mr. Chairman.
Yes. It has to be closed.
Mr. Chairman.
Maybe we are misunderstanding the minister. But from what the leader of government business said, we don't want to insert the words Sierra Leonean for consistency. But there is no way we are going to get a foreigner to head our IMC. There is no way. Because it's a regulatory body. They can have a foreigner heading SLAJ when the space is open up. It's their business. But we will not allow a foreigner to head the regulatory body. But what the minister is saying, let us leave it as it is. When it comes to parliament, or when it goes to the president will advise himself.
Let's put it this way. In the event that SLAJ makes the mistake of recommending a foreigner, and that nominee comes
brought to parliament, it will not be unlawful if it remains this way.
No, parliament will have
it will not be unlawful.
the
We can stop it.
responsibility of accepting
Or reject it. Thank you. If it remains this way, we can either accept or reject, which is open, meaning it is open.
So let's leave the
Mr. Speaker, please. Mr. Speaker, please.
If we
I want
leave
to
it
lend
as
my
it
voice
is,
to this debate.
I agree, but in answer to your question,
Mr. Chairman,
now,
sorry.
it means if a foreigner is nominated by the president for the approval of parliament, and it remains this way, parliament will have the option to allow or reject. It will not be unlawful for parliament to allow. And we are saying allowing a foreigner should be unlawful. That's what we are saying. Parliament may not be convinced to allow, but it will not be unlawful for parliament to allow if it remains this way.
Honorable Daniel, you've been heard. Yes, Honorable.
Yes, Mr. Chairman. And I'm taking the cue from the position of the leader of opposition. Clearly, it is a prerequisite that before you occupy a national office, you must be qualified to be a member of parliament. And for you to be qualified to be a member of parliament, you must be a Sierra Leonean. So I beg to differ from the position of my Honorable Daniel Kouma, that when a nominee in the event SLAJ nominates a foreigner to be appointed by the president for that position, Parliament definitely will have to revert to the Constitution by saying that this man is seeking to occupy a national office, and therefore he must meet the prerequisite conditions, and one of which is for him to be appointed or for him to be approved by this House, he must be qualified to be a member of Parliament. And if he is not a Sierra Leonean, meaning he has failed to fulfill one of the prerequisites. Therefore,
I don't want us to open a debate on that.
So that's my view.
But there is no such provision in this bill.
Mr. Chairman. Mr. Chairman. Mr. Chairman.
AKK.
Mr. Chairman.
Yes.
I want to be heard on this, Mr. Chairman. Mr. Chairman. Yes, Mr. Chairman. How can you tell me to wait? The Speaker needs to tell me that. I have the right to stand to lend my voice to this debate. It is constitutional. Mr. Chairman, I want to make some clarification. Since we are not averse to the repeal of this particular Part 5 of the criminal life of the libel, now we are strengthening the IMC Act of 2020. Approving or strengthening this, even the approval, is opening the space to some international standards. But we are not saying that because of this, we are appealing this, that somebody who is not a national should occupy this position. What Honorable Daniel Kouma was saying, that minister is saying something that is different, is not different. We are not restricting this to just Sierra Leone, but the position is restrictive. So I think repealing this particular thing is not something that we have Sierra Leone to say we would have somebody who is not a Sierra Leone to come and occupy the position of a commissioner of IMC. It's not something that we should even believe ourselves on this particular point, Mr. Chairman, because nobody will come to take such position who is not a Sierra Leonean. There is nothing that has to do with somebody who is not a Sierra Leonean to come and occupy this position. I think that is not something we should label ourselves on, Mr. Chairman.
Based on the voices in the world this morning, I would have easily said, let me accept and let's move on. But, Mr. Speaker, you asked a relevant question which Honorable Daniel Koma was trying to answer. That in a situation in which SLAG nominates somebody who is not a Sierra Leonean based on the 10 years experience that is being given, he appoints the person and that person is taken before Parliament. With this current law we are passing now, we are not obliged, Parliament will not be obliged to say this person is not, whether it's left to the prerogative of Parliament to approve the person or not to. What I am emphasizing, and I remember today the minister is telling me something else. He gave us a clear example of non-Sierra Leoneans who have practiced in Sierra Leone, who have the integrity and what it takes, that if they are nominated, nobody can reject them in Sierra Leone for short position. And today we are here and we are saying, no, it implies. I also know to be a member of Parliament in Sierra Leone, you must be a Sierra Leonean. But what is the spirit behind the law saying? It is clear. The spirit of the law is saying the person must be a Sierra Leonean. Why? Have we asked ourselves why? Have we asked ourselves the question why?
Would you like to see a non-Sierra Leonean take a seat here?
And that is why, because I don't want a non-Sierra Leonean to take a seat here, that is also why I want this to be clear, that the chairman of IMC must be a Sierra Leonean, Mr. Speaker. But if it is your ruling, I think I'll leave it as it is.
Let's go on. The consensus is we keep it as it is. Now, let's go on clause 4 on page 5. Mr. Chairman, what are you suggesting? They are sexual offenses.
Mr. Chairman, it was the view of the committee that in areas where they now say that if you are found guilty of fraud or the like, we now want, because of the sensitivity of sexual offenses in our country, we now want to say for acts that will be passing, if you are found wanting or guilty of sexual offenses, you will not be qualified to hold sensitive national offices. We want to introduce that. I am sure colleagues, members of Parliament will be with us. Because even in the Constitution, it says if you are found wanting of fraud or dishonesty, but because of the way this nation has taken the fight against sexual offenses is concerned, let's say rape and sexual penetration, if you are found guilty of sexual penetration or rape, we are of the view that you are not a fit and proper person to hold sensitive national office.
Okay, so where do you want to insert that? Is it D?
Yes, D. Yes, Mr. Chairman.
Yeah, involving sexual offenses, fraud or dishonesty. Is that what you're saying?
Yes, Mr. Chairman.
Mr. Speaker, Mr. Chairman.
Okay, fine. Now clauses 5, 6, 7, 8, and 9, and 10 are fine. Yes, we are.
Yeah, Come in. No, the point of insertion is what you are looking for. The point. Page. So, what is wrong with in adding to where we have dishonesty? We can continue with the, yeah, Mr. Speaker. We should just continue with D. Okay. All right, okay. Yeah, okay. All right. Okay, thank you.
Mr. Chairman, I'm sorry, sir. I was not there when you discussed this. But 4-1, Mr. Speaker, Mr. Chairman, shall be eligible for reappointment or renomination. I was not there. Reappointment is sufficient.
Yes, indeed.
Because to add the word...
No, it's reappointment appropriate.
Yeah,
Yeah.
For reappointment.
Yes, it's appropriate.
Because otherwise it gives us...
reappointment.
So I'm pleading that we delete...
No, we delete renomination.
Thank you very much, sir. Thank you, sir.
Good.
Yes, sir. On that note, the phrase "as the case may be" should be deleted as well.
Yes,
On that note,
yes.
the phrase "as the case may be" should be deleted. Then who will effect these changes? Let him come here. So let him come to the front.
Okay. Shall we make progress? Page 6. Page 6. Mr. Chairman, I seem to see example of resign. Are you with me?
Yes, Mr. Chairman.
Where the chairman or a member of the commission, forget about that, resigns. Huh?
Yes, Mr. Chairman.
Then you say, look at A. He has resigned. And then in the case of the chairman, the members of the commission shall elect one of their number to act as chairman until such time as the chairman resumes. Resumes what? He's resigned. There's a contradiction there.
Yes, Mr. Chairman. Mr. Chairman, we want you to read further. Yes, we looked at it properly.
But how can you resign and you say you resume?
Mr. Chairman, let me read. Where the chairman or a member of the commission dies, resigns, is removed from office, or is absent for a continuous period of 3 months, or by reason of illness unable to perform the function of the office for a continuous period of 3 months. A, in the case of the chairman, the members of the commission shall elect one of their members to act as chairman until such time as the chairman resumes his office or an other appointed in his stead. So
the difficulty I have, if the man has died, how can he resume?
So yes, that is why it's appointed. If he has died, the one appointed is there.
No, we don't need to read 5-1 in isolation. We should not read 5-1 in isolation. We should read 5-1 in tandem with A and B.
And B.
That is why it should go. We read them in tandem.
We took the
so in days where he dies, there will be a provision for that, which stated. Where he resigns, there should be a provision for that. Where he's absent for some time, against the act, there's a provision. So you don't read them in isolation. Yeah. You read them in tandem.
Yeah. Well, then get rid of the word dies. If they replace you, but read them fine. No.
But assume, not resume.
Yes. That is why they say, oh.
No, but the word resumes, what does it mean?
No, when I put the word assume, the second chairman would assume office.
No, the confusion is the word resumes.
The chairman is in.
in tandem with the provisions we have. 5.1. If you are ill, which I excuse, you resume your seat.
I agree.
But the new chairman, yes, if you die in the event, you are removed from office. Somebody come back, they will appoint another person. So when you are dying, no matter resumption, you have gone forever. There's the reality. So if you are ill with an excuse, you cannot say you can remove the person from the seat. He can resume his seat, chairman. Okay.
Mr. Chairman,
that wording is very clumsy.
Mr. Chairman, I also took your point. Mr. Chairman, we took your point. Your thought was heavily our thought until we looked at it carefully. Mr. Chairman, for all of us to be at ease, we'll read it again holistically and see if we can leave it or we can amend it.
Fine. No problem.
I will start from 5.1. We have the chairman or a member of the commission.
No, leave it. This draft man will take care of it.
Grateful, Mr. Chairman. Grateful.
So we move on then to
Part
3.
Yes, Mr. Chairman.
Yes.
That is on page 8. Part 3 is on page 8 of the bill.
Mm-hmm.
Page 8.
No, page 8.
You come on oversight. So we are recommending that up to clause 13 be approved. So you can take page 8 and look at it down to page 10. Because we are recommending that clauses 11, 12, and 13 be approved.
Okay.
And 13 takes us to page 10.
Any problem with that? Good.
Yes, Mr. Chairman.
On which
yes,
one?
I have slight problem with
which
clause
clause?
10, clause 10, sub-clause 2 of page 8, sir. I read, a member of the commission or committee of the commissions shall not be personally liable for any debt or obligation of the commission.
Mm-hmm.
I want this one to be a little bit beefed up to avoid a situation wherein a member of the commission may use his office clandestinely to go into an obligation of debt using his office, the authority of his office, in the name of the commission.
Mr. I take his point, but in that case, if it is realized, then that is fraud.
Because it's not authorized.
Yes, it may be fraud, but what happens in an event in which maybe the person might have left the job or is deceased?
It's not authorized. It's fraud.
At least adding held in good faith in the name of the commission would suffice, would save the problem, sir.
Mr. Chairman, I will suggest these are clauses that normally come in so many bills that we look at. It's standard. It's a standard clause, Mr. Chairman.
Okay.
That you cannot be liable for an act of the commission. It's like a company, a limited liability company. The liability of a company does not extend to you until the bill is lifted.
Very well. Take us through to 15. Or 14, you say.
We are now on the report, we are on page 3. So we are saying clause 14, sub-clause 2 be amended by inserting.
No, hold on. Take us to the actual page on the bill.
Okay.
Is it page 10?
We are on page 10.
Page 10, I have issues.
We are on page 10, clause 14.
No, page 10 still. Let me go back. Before that, define. Mr. Chairman, I've said in the sexual offenses act bill in discussions that passed into law now, we don't make crime lucrative. And you said you asked us a question that we are going to repeal the Public Order Act.
Mm-hmm.
And in the debate, somebody asked, in other countries they are paying far higher amount. But you asked that question. For me, if you make crime lucrative, you will not get your end result. Sometimes fines can even stop you to commit a crime. The punishment levy. So if you are taking from 30 million We are talking about 15 million. Let us have a range. Remember when we are about to pass the Anti-Corruption Act, we said, let us have a frame so that in terms of fines, you don't have, it was done in this particular bill also, where you have 3 million to 5 million. For me, 15 more than, not more than 30 million. No, I was expecting also to have 30 million, not more than 60 million. We don't want to make crime lucrative. Oh yeah, you have to be very responsible. We are supporting you, but you also have to take into cognizance that we are dealing with people. There are this is a admirable profession. We should be seen doing the right thing. You cannot be afraid if you are doing the right thing. Don't be afraid if you are doing the right thing. Be open up. If I have committed an offense, let me be charged. Because I have been doing the repeat because we are very clear in our minds that we are going to have people practice journalism in the best way they can, in a professional way. So don't be afraid of the fines. So I want us to stay by the fine we have, not less than 30 million, not more than 60 million. That's my proposal. We are doing the repeal.
Well,
fines,
which clause?
Clause 13. Page 10. Let me tell you, very easy. Page 10, clause 2 on that. 13, sub clause 2 here. Thank you. So I don't want to. Just have the range, but not less than 30 million.
Mr. Speaker, sir, I also have issues with clause 13. Yes.
Hold on, member. Let us deal with this one.
Let's deal with that one first.
Okay, let's deal with that one first.
You are saying the figure should be higher.
Yes, Mr. Chairman. Yes, sir.
30 million. 30 million. Okay, let me put it this way. Liable to a conviction for a fine not less than 30 million, at not more than 60 million.
Mr. Chairman. Yes, sir.
Mr. Chairman, can I?
It's in violation of, if you are not given a license, you want to register. It's in violation.
Yes, Mr. Chairman.
You cannot operate the way you feel like.
Let me deal with what the leader...
Mr. Chairman, you come. Unless...
Honorable members, I hope you are with us.
Mr. Chairman, in the report...
The proposal is that there should be a range.
Yes, sir.
The minimum fine should be 30 million and the maximum, how much did you say, 50 or 60? 60.
Yes, sir.
On that?
Yes.
Yes.
May I
check.
Yeah, Mr. Chairman. May I submit to our leader that in as much as we want to make sure the regulations in the IMC Act protect the states or protect public interest, but yet the amount of money in question should be given rational thought. And so for me, we want to look at the mean in between 30 to 50 rather than 30 upwards. That's my submission and that's my view, Mr. Speaker.
Yes, Mr. Speaker.
And I'll tell you, I passed through a section of Freetown, and I was shown the Sheikh's investment. It stretches quite a long stretch. You can liken it from here to State House. Okay, yes, Mr. Chairman.
I take after the leader, he has been a top legislator when it comes to punishment. I will go by his suggestion because when you look at the context of Section 13, it's saying the person or institution shall not carry out radio, television, or direct to home digital satellite and service broadcast unless that person or institution obtains a license issued by the Commission. Publish a newspaper, magazine, or magazine unless the person or institution is registered. In that vein, if you are doing it without registration, you are violating the very commission for which we are legislating. So to prevent them, to deter them, I will go with him for us to say not less than 30 million and not more than 60 million. So by the quantum of the monies itself, it will prevent people from establishing this radio station. Mr. Chairman, I'll tell you the reason why.
No, wait, please. Is there a consensus?
Yes.
Mr.
Chairman,
I
hold the contrary view.
Huh?
Mr. Chairman, I hold the contrary view. Mr. Chairman, when we are talking about fines, I am reflecting my mind on the EPA Act of 2008, which also stipulates that a company, we are talking about mining companies, manufacturing companies, that operate without acquiring the proper licenses, the EIA licenses, can only be fined 25 million. That is after conviction. And we are talking about media institutions whose capital is not even up to what we are asking as a fine. Are we going for a foreclosure or are we trying to protect the media? For me, the amount is too much, the amount is exorbitant, and the amount is out of this world because the people, most of the media houses, from the legislative committee meetings that we have, we realize that the media, they were pushing for more of sole proprietorship. Why? Because most of the people in media businesses are operating as a sole proprietor. And now if we are saying for non-registration, for which we have thousands of mining companies that are operating in this country without obtaining EIA licenses, they are only fined 25 million upon conviction. And for a foreign company, fined $10,000. And if you are saying you are going to find a media house in excess of 30 million, that is too much. I was even thinking that 30 million will be the maximum, and it will range between 10 to 30, 30 the highest point and 10 the lowest point.
And this is important. I will want to be heard. I had wanted to give the rationale for this. We are talking about somebody who is operating an illicit radio station, television station, that will be broadcasting. He's not being regulated. He's not the damage that that person will cause to society. No, I am not comparing it to the mining. You can bring your act and it can be amended.
Otherwise, you repeat not the law.
You can bring it and we can amend it. But the damage that that person will say, let's say you go to Kailahu and you are preaching hate speech by an illicit radio station that you are operating. So to debar people from that practice, the fine has to be high. Mr. Chairman, we have the same proposition in the Telecommunication Act. When you operate an illegal telecommunication, the fine is 5 times the license fee. If you are to pay $500,000 for license, the fine is like $2.5 million because of the damage that you will cause.
Okay.
So that is why people have started.
Yes, sir, Mr. Speaker.
Just a minute. If you look at yes, somebody asked on the back why the fine is so huge. If you look at the phrase itself in 13, it's very clear that these are intention and act. You know, I'm not registered. I'm supposed to take license, and you're involved in broadcasting. That's why you have to be fined with this amount of money, because it's an intention and act. What you are talking about, those are different things. We can, even if the house comes here, we fine you again. We increase the fines, because all those fines we are going to look at. I said, let us don't make crime lucrative. I will stand by that. I will always do. So let us have between the range of 30 million to 60 million. I want us to be very consistent, because the last time...
Do we have a consensus
yes.
on that?
No,
Mr.
Chairman.
Mr. Chairman. Mr. Chairman, sir.
Mr. Chairman, can I be heard on this?
Mr. Chairman, sir. Please, sir, Mr. Chairman. Can I be heard? Please, sir.
No, let me give him an opportunity.
Okay, sir. No problem.
Thank you very much. I just want to take a cue from Honorable Tawa. It is clear that we do not want to tighten up this whole thing, right? In the suggestion he put forward that we put the fine around 10 to 30 million, I go by that. One thing we should know, the area of the registration that the chairman of the legislative committee is emphasizing on, right? We can attach something to it if we want, instead of us making it giving it the blanket fine at 30 million to 60 million. I believe.
Okay, you made your point. You made your point, please.
Thank you.
Thank you, Mr. Speaker.
Yes, Mr. Chairman.
Please, sir.
Yes,
Thank you, Mr. Speaker. Mr. Speaker, with your permission, I just want to read section 13, which says, a person or institution shall not carry out radio, television, or direct or home digital satellite. That's where I'm coming. I underlined it because we must consider the fact that the world is becoming digitalized all over. If you, Mr. Speaker, as you know, you travel abroad on and off, now, most of the time now, most of the televisions that we'll be having very soon in our country will be automatically digitalized. You don't need a satellite. You don't need a satellite to operate it. It's a matter of wording the word properly so tomorrow we don't find people unnecessarily. Because we cannot be running into everybody's home who have bought a television from abroad that is automatically digitalized. Can we look into this wording, Mr. Speaker? I'm not challenging the fine or whatever, but let us watch into the word digitalized television. I've read it.
But read it
Thank
carefully.
you.
Read it carefully.
Thank you, sir.
We are not talking about.
Mr. Speaker,
We are not
the wording says television.
Honorable. It's not the domestic user we're talking about. This is somebody who is in business.
Mr. Speaker, sir, with all permission, what we are debating here today has led us from the beginning from internet and how we protect journalists. Digitalization is becoming so controversial that somebody can sit in his house
Mr. Speaker,
and television and write something about somebody else and tarnish his character. It is difficult to control. Let us be mindful of the technology.
Mr. Chairman.
I know where you're coming from, Mr. Speaker. All right. Okay.
Chairman,
Are you yielding?
no, you don't, forget about him, sir. I will ask let us ask the minister to intervene.
Okay.
Thank you very much, Chairman, honorable
Let's
members.
proceed right now. Okay. Put your mic on.
I definitely appreciate his passion for unintended consequences. But the context here dictates that for people operating DTH and other satellite services, they have to register with us before they begin to beam. It is not ownership in homes, offices, or other places that we are talking about at all. We're talking at a very, very macro level. The ownership, for example, K3 TV, AOIV, and others that might join the market when this repeal is done, when the new IMC bill comes into effect. Yes,
Honorable Jallo, are you in that business?
Yes, sir. Yes, sir. Thank you very much, sir. Mr. Chairman, Mr. Chairman, sir. Mr. Chairman, sir.
Are you in that business?
I am in the business of the television. Mr. Speaker, sir, please.
In the digital business.
What
Are you in that
the
business?
minister have just said, he's completely in line. We are not questioning that. But my fear here is, Mr. Speaker, if you allow me to put my case across, the digitalization world is becoming so advanced that one day somebody will sit in his living room and write about you, Mr. Speaker.
Yes.
And that person is not licensed.
Yes.
How do you prosecute that person from the 60 million the leader is questioning now?
So you want it higher?
It's a matter of let us just agree that how we put the bill into order properly, sir.
So what do you want? 100 million?
100 million, sir. We'll be fine. Thank you.
Mr. Chairman. Mr. Chairman, sir.
Mr. Speaker.
Honorable Jallo.
Yes, sir.
In order to save time.
Yes, sir.
Negotiate with the leader. Whilst I listen to another.
Okay, sir. I will move over to him now with your permission, sir. Please.
Mr. Chairman.
Yes, Paramount Chief.
Mr. Chairman.
I'll come to you after.
Mr. Chairman, now that we are talking about publishing a newspaper, magazine, or news letter, we have to
define what is a newsletter here. And also, we have to look at the technological advancement.
No, Chief, I think we got rid of that word.
Sir? Okay.
We got rid of that
Then,
word.
Mr. Chairman, I want the minister to take note for future legislation. Mr. Chairman, I'm happy the leader of the House is here, leader of government business, and the leader of the opposition are here. We've been to the Committee on Information and Communication. Mr. Speaker, Mr. Chairman, I want the minister to note that we have so many difficulties in terms of licenses in this country. Like DSTV, we are arguing that others we are carrying out jobs they should not be doing, and they don't have the licenses for that. We need good regulations because at NATCOM, we want to see who should publish, who should communicate on these issues. It's very important, sir, because we are having that difficulty with K3 and others. And DSTV is complaining that AYV and SLBC or whatever are carrying out football when they should not. So when we talk of licenses, IMC should also look into this to see whom they are going to give the licensing and who should not be given licenses on this. I want you to take note of that. I'm not going to raise it now, but I'm giving notice to you that these are problems that we are facing, Mr.
Thank you, Honorable Paramount Chief, but the issue before the House is specific, is the penalty and the quantum of that penalty.
There should be a range.
Yes.
And not only limited.
So you agree with the leader?
Yes, but when he said, if we are going to say 30 or
30 minimum, 60 maximum.
You want me to agree? Sludge, are you going to agree? Because
Mr. Minister, you have any problems with that?
Well, this is a country of law and order. If you arrogate yourself the right to publish or to go ahead to beam DTH here without authorization, let the law take its course. I will be in a place to speak about journalists who are in the course of their normal duties commit infringements. But if you don't want to obey the law, I'm told even in hell order is the first law. Let the chips fall where they may.
Mr. Chairman, I want to make a quick comment.
A retraction?
I'm going to retract, but I want to make a quick comment, Mr. Chairman. The Honorable Paramount Chief made mention of some digital satellite television channels, stations operating. And for most of us in this room, and maybe on the other side of the chair, the journalist, we are using a digital satellite television station that is not registered in this country. So what will happen to that? Most of us are subscribers of DSTV Nigeria. Most of us are subscribers to DSTV Nigeria. And there is DSTV Sierra Leone. So what happens to DSTV Nigeria when they are not registered to broadcast on the digital satellite television in Sierra Leone?
They are outside the jurisdiction.
Agree with what the leader of government business said.
Chairman, I think he's talking about something very important. We need to protect our own industries. We need to protect our own indigenous business people. That one can come under. We are bringing the NATCOM Act for amendment. The cybercrime is coming also. We are going to deal with those things. Thank you very much for raising them. But Mr. Chairman, that is a very important thing. Revenues are not going out of this place. Yes. They're now going to Nigeria. There is a formula they used to have. Why do you have lower subscription? Why do you have higher subscription? So the formula is based on population size and subscription. So we do that one under the NATCOM. Let's focus on the IMC. So you considered, right? Okay, Mr. Speaker, let's go.
Fine. Okay, and that's for 13. Anything on 14? Paragraph 14? We deleted B, by the way. B is gone. So how will it read?
Yes, it will read, the commission may suspend or cancel a license where it is satisfied that the holder of the license has violated the terms, conditions of the license. To B, it is in the public, 14.2. Okay, 14.2, where the commission intends.
Before you go there, before you go, I think the consensus we had reached earlier is that B should go.
Yes, B should go.
Good.
B should go under 14. B should go.
Okay, go on now.
So under 14.2, it will now read, where the commission intends to cancel, where the commission intends to cancel or suspend a license.
Okay.
Under subsection 1, it shall give written notice to the holder of the license specifying the, so the word intends fit jacketed.
Okay.
Memory.
Yes.
There. You can intend, you don't do. But we can say where we find the violator, where the commission finds the violator.
No, Mr. Chairman, if you have to know the purpose of the word intends as we go ahead, because the effect of this word intends, you have to find it in the subsequent provisions, sir. So you have to read about 2 or 3 other sections before you can actually get the purpose of the word intent.
Very well. Page 11, clause 15. Yes, Mr. Chairman.
Clause 15, we are saying the committee proposed the insertion of a new subclause 4 and 5, and to read, A, the commission shall proceed to cancel or suspend the license where the holder of the license fails to comply with paragraph B and C. Mm-hmm. Then B, the commission shall restore the license when the holder remedies the situation that gave cause for the cancellation or suspension. So there are conditions given. If you actually remedy it, then your license will be restored. That's under 15. 15, the bill is saying the commission may suspend or cancel a newspaper, magazine registration where it is satisfied that the holder of the certificate of...
No, we have removed that from the battery. Anywhere you have newsletter, you remove.
Yes, anywhere there is newsletter, you remove. So we are saying under 15 that a new clause 4 and 5
be added,
and I have just read the content or the text of the addition.
Very well, and I also want to draw attention to paragraph B at the top of page 12. That too goes.
Yes, that one goes too. On that is 15, under section 15, subparagraph B.
Very well.
If we are to proceed to 16, I will go there, sir. Enforcement.
Court of Appeal should not be the first Court of Appeal, but the High Court. The records.
Yes, Mr. Chairman, when we got to the court, a point I know you would have seen in the bill, we noticed that in some section of the bill, reference was made for aggrieved parties to appeal to the appeals court. But in other sections of the bill, reference was made to the High Court. Mm-hmm. So when we looked at it properly, we realized that the powers of the commission that was to be driven from the High Court was limited to bringing evidence before them or summoning witnesses before them. But it was not generic. It was not all the powers of the High Court that was given to them. So we also realize that if you say people should apply or appeal to the appeals court, it is normally very daunting for the Chief Justice to empanel appeals court and for the appeals court to be empaneled and decisions taken in 30 days. So we said for those actions, they can go to the High Court. So we actually have High Court uniform right through the bill instead of appeals court.
Very good. So now it's uniform right
It's uniform,
across.
Mr. Chairman.
Okay.
And thanks to the leader, who is my senior at the bar.
I presume that there is a consensus for all of this. Good. Let's move on.
So
now part 4.
Mr. Chairman, wasn't it said that it be part of the bill? So if we scrutinize it up to this point, maybe you might want us, as you usually do, that it stands part of the bill, and then we started scrutinizing up to clause 16.
Hold on.
So we scrutinize everything?
No. No.
He has put a question.
Honorable members, the question is that parts 1, 2, and 3, clauses 1 through to 16, as amended, stand part of the bill. All in favor say aye.
Aye.
Those against say nay. The ayes have it.
Clauses 1, 2, and 3.
Mr. Minister.
Form parts of the bill. Mr. Chairman, honorable members, I move that parts 1, 2, and 3, clauses 1 to 16 stand part of the bill as amended.
Honorable members, the question is that parts 4, 5, and 6, clauses 17 to 38 stand part of the bill.
So on clause 17 and 18, we are recommending that it be approved.
No, at the end of it. Go on, clause 19.
So clause 19, we are saying that it be amended as follows. A, subclause 1, paragraph A, be amended by inserting at the end of the sentence the following words: for newspaper and magazine.
Sorry, where is that?
On the
page 13 you are, or 14?
17, we are on page 13.
Uh-huh.
So 17 is reading, the commission shall have a secretariat which shall be responsible for the efficient discharge of the functions.
No, that's approved.
Yes, that's approved.
Go to 19 now.
Yes, clause 19. Clause 19A, we say an applications committee responsible for receiving and screening applications. So we are saying clause 19A, subclause 1, paragraph A be amended by inserting at the end of the sentence the following words: for newspapers and magazines. So when it will now read, an application committee responsible for receiving and screening applications for newspapers and magazines. So at the end of the sentence, you add newspapers and magazines.
Hold on. Yes, Chief.
Although he said it has been approved, but it has not yet passed the well of Parliament. He said the Commission shall have a secretariat which shall be responsible for the efficient discharge of the functions of the Commission.
Mm-hmm.
2, 17.2.
Mm-hmm.
The secretariat shall be headed by an executive secretary who shall be a full-time officer not below the rank of permanent secretary in a government ministry appointed by the commission. In this case, what we are now saying, we have to have the commission, by having all the commissioners ready before they appoint an executive secretary. So, who is going to prepare the office before the commission comes into operation? Because there are times here when not all the members were appointed automatically at the same time. You have sometimes they appoint 2, 3 without even having all the commissioners. So I think we should find a way, better way, to have the executive secretary by the president to head it, then the commissioners come in later. You see, but now we are putting the cart before the horse. So for me, I will beg the minister and Sludge and this noble house to first have the appointment of the executive secretary by the president. You see? So that is my own thinking.
Honorable Paramount Chief, perfectly right. But this is not a new commission. There is in position an executive secretary.
No, we are going through a whole act, a new act. So let us don't go through that. If the president wants to renew the person there, that is okay. But if you look at it, you are coming from abroad. You read this, it is a different issue. It's very different. There is already we are saying, look at Mr.
I want you to look at the side notes, continuation, side notes, sir.
I see it.
Yes, side notes.
Secretariat and staff of commission.
No, continuation. There is somewhere.
Where? Other staff commission?
Yes.
Other staff of
Go
commission?
under, yes, under 2. Continuation of the commission. Part 2. Continuation of the commission. So
Where?
it means the status quo continues. Part 2, under page 4.
I'm not saying all that. But the appointment of the executive secretary should come from the president. Yes, but they can replace him. No, but now you are going to have new commissioners. Huh?
Paramount Chief, my understanding is the office of the executive secretary is in charge of administration.
Yes.
So he is always there at the commissioners' meeting.
Yes.
As we are talking, this commission is a continuous commission. The executive secretary is already installed. So you are not going to get rid of him because of this amendment. This is an amendment. We are amending the IMC Act.
Look, but when you go to 17.2, read it. The secretariat shall be headed by an executive secretary.
Yes.
Who shall be a full-time officer and not below the rank of permanent secretary in a government ministry appointed by the commission.
Yes.
So that means the new commission, when they come in there, they will appoint their own secretary.
No, sir.
Mr. Chairman.
Chief, before you sit,
yes, sir.
I thought you were going to quarrel with the word full-time. Mr. Chairman.
On that one, full-time.
Why full-time?
Section.
Why not simply say he shall be a public officer?
Exactly.
Consistent with section 171 of the Constitution.
Of the Constitution.
Granted.
You see, that's why I read the two of them.
Full-time is overemphasizing the word, because we were just saying.
If it's going to be a permanent secretary rank, it goes without saying.
Yes, it goes without saying. But the emphasis again, Mr. Speaker, maybe might not have caused much damage. It's in the Parent Act. Because we are merely amending. Some of the provisions in this amendment, we are merely just transposed from the act we are amending into this new one. The ones they wanted us to add, they added into the new one. But Mr. Speaker, Mr. Chairman, I always drink from the well of your wisdom. If the word full-time is overemphasizing the office, then
You shall be a public officer. That's
Yes,
enough.
yes, we shall get rid of the word.
Mr. Minister, are you satisfied?
No, let me come before he comes in.
Yeah.
So there is an amendment. We have the Parent Act. I want us to look at the Parent Act.
What does it say?
The Parent Act should be 10, clause 10, section 10, subsection 2. The secretariat shall be headed by an executive secretary who shall be appointed by the commission upon set terms and conditions as the commission may determine. That is the best, Mr. Chair. Let us have this one. It takes care of all what we are talking about. Let us maintain the spirit of the parent statement.
That's the 2000 Act?
Yes, it's the 2000.
Read it again, please.
The secretariat shall be headed by an executive secretary who shall be appointed by the commission upon such terms and conditions as the commission may determine.
Very well.
Yes, thank you.
Are we agreed?
Yes.
I mean, suppose they want to remove the person they found there. That's may determine.
Okay, let's make progress, please.
Mr. Chairman, we are still on
19.
19. So we have said under 19.3, still looking for my own 19. We have said, yes, we have said sub clause 3 by deleting the word with and replacing it with the word by. So if you look at sub clause 3, it will now read, it reads originally, the executive secretary shall be a person, 19.3. A complaint sent to the commission under subsection 2 shall be supported, instead of with, you now improvise it with the word by, shall be supported by an affidavit.
Very well, go on. Then 5.
5, subclause 5, be amended by inserting the following words, and an affidavit of service duly served by the chairman immediately after the word's appearance. So if you look at subclause 5, it will now read, where a person or media institution fails to appear before the complaints committee after a summons has been issued twice for the appearance, the complaints committee shall proceed with the matter as if the person or institution is before it. So we are saying, following the words, so we are saying after the word
appearance, there is no word appearance there.
No, we are adding it. Because, Mr. Chairman, we looked at the situation where, let's say, a media institution was not served. And the commission holds the view that he was served.
No, I beg your pardon, the word is there.
Yes.
After appearance.
Yes.
Very well. The word is there.
So we are now saying that when you summon this person, you have to file an affidavit of service with the commission, so that the affidavit of service will be evidence to show that this person was actually served. If it doesn't come now, you can proceed against him.
Very well. I see no objection. We proceed.
Clause 7, paragraph B be amended by deleting the word cost and replacing it with the word fine. So it will read, where the commission is satisfied that a case has been established against the person or media institution, it may order the person or media institution concerned to, on the other page, publish an apology and a retraction, and may in addition reprimand the person or media institution concerned, or B, pay cost. So it is the word cost we are substituting for fine. The reason, Mr. Chairman, is lawyers will argue that cost is for me. Fine is normally generic, is to reprimand somebody for some wrong done. So we remove the word cost and put the word fine. That was our recommendation.
Okay.
Mr. Chair. Mr. Chair.
Yes.
He's a lawyer. He wants money. You put in there, pay a fine, A, and B with a cost. You can pay the fine, but you have to pay the person you damaged had paid the lawyer. You have to refund the cost of that. So let us put a fine and a cost. The cost, they know, the lawyers. Don't you want to be paid back?
Again, it depends.
So
it depends on the case.
So for me, I will put both the fine and the cost. And that the court will determine the cost now, or the commission. I hope you will support me on that. No, but all with cost, all with. I know. No, but sometimes
I want to create the indulgence of the learned paramount chief for us to leave it at fine.
I think it's agreeable.
Grateful.
Let's go to subparagraph 8. I'm just curious. Mr. Chairman, 8.
Yes, financial provision be approved.
No. You said where a person or media institution fails to comply with an order of the commission made under paragraph B of subsection 7. Why? Part 5.
Mr. Chairman. Mr. Chairman.
Yes.
I know this is your domain. You are an expert in English. We want to look at subsection 7 of 19, where we said or pay costs, where we now substitute it for fine. The word or